Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives in New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Michigas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Slap Down Tuesday, everybody. Happy Slap Down Tuesday. How are you doing today? I'm doing great. Had a little propofol nap this morning. And what's better than a little propofol nap? If I start acting a little dopey or loopy, little cupcake will tell me. I had a colonoscopy this morning. Everything's great. Come back in 3 years. You got to do it, you guys. You got to do it. Just go do it. Do it. All the things, the colonoscopies, the mammograms. Make sure you do all the things. Make time for yourself. Because if you don't take care of yourself, how are you going to take care of anybody else? You're not. I was watching Peter too. I was like, hurry up, Peter, hurry up. Finish. Wow. Okay. So here's what happened this morning. Well, before we get into that, let me tell you this. Because yesterday we covered the final pretrial conference on Lindsay Clancy. And Lindsay Clancy's case is going to trial. Well, they're going to start jury selection next Monday, the 20th. Guess who's on the Commonwealth witness list? Are you ready? A couple names you might recognize. First, Maureen Hartnett. Remember her? Isn't she the one who didn't pass her certification test or something from the crime lab? Second, Renee Stonebridge, the queen of all things brain. Renee Stonebridge. Third, ready? Oh, wait a second. Let me get my drum roll. Hold on. Where's my drum roll? Ian Whiffen. Ian Whiffen is going to be testifying for the Commonwealth in the Lindsay Clancy trial. Remember? Well, maybe you don't remember because maybe you're not even following the case. Lindsay Clancy is a Duxbury mom, a nurse who is charged with and accused of and did take the lives of her 3 little children with exercise bans after sending her husband out for takeout food. Then she jumped out a 2nd-story window trying to take her own life, but now she is paralyzed below the waist. She has been held in, I think, Tewksbury, right? Or Tewksbury, the mental hospital. I'm not sure. Yes. So, but part of their theory is that Lindsay Clancy Googled the restaurant and how long it would take to get back and forth to the takeout restaurant as premeditation, that she sent her husband out for takeout food, knowing how much time it would take him to get there and back so that she could take the lives of her children, right? What's Ian Whiffen going to do? Is he going to come in and say that the timestamps on her Google searches were correct or that they're incorrect? Oh, I can't wait. I said last night, I said, this is too heavy for me. I can't cover it gavel to gavel, but we'll do certain days like openings, closings, Tewksbury. But the day that Ian Whiffen testifies, you bet your ass we're going to be right there live. Tewksbury State. Can you imagine that they hired even? Is he on their payroll? I guess he's going to be on their payroll. You know, Celebrate's biggest client is law enforcement. That's where they make their bread. That's their bread and butter. Worldwide, I think. So do you think Kevin Reddington is going to shred Ian Whiffen? Maybe, just maybe. I mean, it's going to be amazing. It's going to be fantastic. All right, today's motivational quote of the day, because we all need it. Tuesday, July 14th, 2026. Ralph Waldo Emerson said, "Don't be pushed by your problems, be led by your dreams." That's a good one. Don't be pushed by your problems, be led by your dreams. I like that. Thank you, Ralph Waldo Emerson. Mass Dad gave me that info, and he's the one who's got all the receipts. So I don't have it to pull up for you, but I'm going to trust him about Ian Whiffen. Okay, we need an affirmation for a badass. And then there were many of you who could not find this hearing this morning. And with good reason. I'll tell you why. Hang on. Here it is. Affirmations for a badass. You are effing amazing. Rock that shit. You're effing amazing. Rock it. I love it. I love it. I love it. Oh, thanks, Mass Dad, for the receipt. I trust you. Maureen is the one with the mirror image of the bumper glass, says Overruled. Sit down. Yeah. It wasn't she also the one that didn't pass her credentials or something? Whatever test she was supposed to take, she failed it. Like a Chastity gift and 5 memberships. Thank you so much. You're amazing. Hillary, thank you for your 10. Says Kelsey Fitzsimmons' restraining order was officially dropped. That's awesome. The one that Justin had against her. Fantastic. Thank you for that. And Overruled Sit Down says Maureen's the one with the mirror image of the bumper glass. Thanks for your 5. WCVB aired the hearing this morning only on their website. So I watched it on their website. And many of you were in Grant Smith Ellis's chat. And thank you for that, because I saw that you guys were over there too. Because it was not on YouTube at all, except for Grant, as far as I know. And so shout out to Grant Smith Ellis for doing the Lord's work, live streaming. He wore my hat. I went to Cancun with Melanie Little hat on today, which he also wore yesterday at the courthouse. He loves that hat, and I love that. And so as a shout out to Grant, I'm going to use his stream to stream it for you, because he didn't comment during it. So it's perfect. I've also linked his channel below. And listen, the Grant Smith Ellis Redemption Tour is something that I'm here for. I am here for it. And he's doing great work. He's out there doing the Lord's work. He's doing a lot of other reporting too on the war and a lot of very in-depth stuff. And he also is very smart. He's very smart. He talks very fast, because I think his mind moves very quickly. And he talks even faster than I do. And he's got good analysis, and he's graduated from law school. And I'm really impressed with his redemption arc. And I hope that you will give him a like and a sub. So there's that. Okay. So today is Slapdown Day. Today's the day when Karen Reed and Aidan Kearney's attorneys argued their motions to dismiss in the defamation case. The defamation case is the one that is brought by Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert against Karen Reed and Aidan Kearney, that has been removed from Barnstable to Plymouth Superior Court in front of Judge Gildea. We went over both motions. We went over Karen's motion to dismiss, and we went over Aidan's motion to dismiss. We went over the response to Karen's motion to dismiss, not Aidan's. It's similar, not exactly. They're going to make some arguments today that are interesting. And what does it mean to be a towel? It's a South Park reference. I'm not really sure. I'm not a South Park super fan, but it has to do with South Park. And that's Grant's channel is called the Towel News Network. TNN, the Tower News Network. Towel News Network. And everyone's a mod. Everyone's a mod. There were some trolls in there, though, today. I noticed there were some trolls in there. But thank you to all the cupcakes that were over there watching him and supporting him. And he's funny, too. He's funny, you know? But also, like me, he goes off on tangents. So I get it. I get it. Linked below this video are the links to the stream where we went over Aidan's motion and the link where we went over Karen's motion and the opposition to her motion. Today, we are going to see Chris Mattei argue against Jeffrey Pyle. I'm a big fan. Let me just tell you something. Jeffrey Pyle is a really good attorney. He's a really good attorney. And when I did a little bit of, just a little bit of research on him, he's like the First Amendment guy that the media companies go to when they want to argue things like First Amendment rights. He's the man. And Damon Seligson is going to argue a little bit too. And we're going to see what Judge Gildea has to say. I'm going to try and modulate it for you. There are no closed captions on this. I apologize, but really we got to get what we get and we don't get upset. All right. So it starts kind of in the middle. And even though the WCVB camera was in there, the CBS Boston, I guess that is, they did not post their stream except for live on their website. And you can't even watch it now on their website. So thanks to Grant for doing the Lord's work. It's going to start mid-sentence. And so that's where we're going to have to start. As always, I do stop and comment because unlike some people who are very good at recapping, Andrea Burkhart is one. She can watch a hearing for 10 hours and then she'll take a break and then she'll do a 2.5 hour recap. I can't do that. That's not me. I can't do it. Well, whatever this is, it was CBS Boston. Maybe it's WBZ. All right. Maybe I misnamed them. WBZ is what I meant to say. Okay. Hold on. Let me just make sure. No, it was WCVB is what it was. They're what? ABC? Whatever it is. They didn't put it up on YouTube. That is what it is. Okay. All right. So we're going to start off with Chris Mattei is already up, and I'm not really sure why, because it's not his motion. Tewksbury. Yes. Got it. Got it. I love when people are behind and then they're correcting me and talking about the things that we were talking about 2 hours ago. All right. Here we go. Starting, this is the hearing from this morning. It started at 10 a.m. I don't know who was in the courtroom. I don't think Karen was in the courtroom. I know Aidan's on vacation, so he was not in the courtroom. And I don't even think Aidan was able to watch it because he couldn't find it either. All right. Here we go.
In a conspiracy to defame the plaintiffs. Number two, what we think is crucial about Cardinal's finding is that the court commented that the petitioners in that case were involved in an effort to directly petition the government. Yes, the conduct at issue involved 4 paragraphs in a magazine article, but they had previously directly engaged with federal agencies responsible for environmental protection and the like. What Mr. Colin is now trying to do is convert whatever history he may have had, in his words, of exposing corruption or going after the police, and making that what he was doing here, when what he is alleged to have done here is not criticize the DA's office or criticize the police department, but very directly accuse private citizens of murder. So that is, I think, never having petitioned the government directly as the activists did in Cardinal. So we see Cardinal as standing for the important proposition here that anti-SLAPP protected activity has to be tethered in some way to an effort to directly seek redress from the government or indirectly seek redress from the government. Here, Mr. Kearney has not argued in any way that his false accusations against our clients that they had committed murder was a message that he conveyed to the government, that he intended to be conveyed to the government, that he had any mechanism for reporting to the government. And on the one occasion where he actually was given an opportunity to directly petition the government on the issues, he declined by invoking his rights under the Fifth Amendment because he believed, rightly so, that responding to inquiries in connection with any sort of petition would expose himself to criminal culpability.
That's rich. That's rich. bringing up the fact that Aidan didn't testify at Karen Reed's trial as evidence that he knew that what he would say under oath would be defamatory when he's facing criminal charges. This is Chris Mattei, Mattei. He is the attorney who got the default judgment and the big verdict against Alex Jones. That's him. And that's a wild argument to make, okay? Because in the United States of as such America, every defendant is afforded certain protections. You are innocent until if and when proven guilty, and you do have the Fifth Amendment right against self-incrimination, okay? You cannot be forced to testify. He had criminal charges pending based on this same BS. There's a hearing today at 3. It's in federal court. It's not going to be televised. There's no cameras in federal court. Let's try and stay on topic. Can we? Okay. So I don't know if this hearing started off with Judge Gildea asking Chris Mattei specifically about this case. I don't know if someone else was arguing first and then he pivoted to this, because the judge is going to ask some questions during this hearing. And so let's see where it goes from here. But it did kind of start. I don't know how late it started. I don't know if anybody is here right now that was in the courtroom today and how much the camera missed, but this is where it's starting. And it should be starting technically with Jeff Pyle, because it's his motion and Karen's motion. So let's see. Yeah, they put Aidan on the witness list in Karen Reed's trials to keep him out of the courtroom, in my opinion. They didn't need his testimony for anything. What would he have testified to? He's not a witness to the murder of John O'Keefe. They're trying to rope him into some testimony so they could do exactly this and sue him, because they've just been waiting to sue him. And now they did. Let's keep going.
So that's why we think Cardno is important here.
So is the relevance of his invocation of the Fifth that he did not avail himself of the opportunity?
Correct. I think one of the things that the court is going to be asked to consider is whether there are objective indicia. This is from Blakesley. Objective indicia of the plaintiff's intent to reach a governmental body in his petitioning activity. And
he's actually arguing with a straight face that if Aidan Kearney really was petitioning the government, he would have gotten on the stand and testified in Karen Reed's criminal trial. That's the only way that he can petition the government, by actually getting up and testifying under oath. He's got a lot of wild arguments. This is just one of them.
One fact that I think is important here is that of all the activity he engaged in, all of which was, in our view, non-petitioning and not intended to reach the government, or designed to reach the government, when he had an opportunity to petition the government, he declined to do so. We think that's an important objective indication that his intent was not to reach the government. In fact, his intent was to attack and defame private citizens.
So, Attorney Pyle, what do you say to the relevance of the Fifth Amendment?
There is no relevance to the invocation of the.
Okay, this is Jeff Pyle. And if you watch his face, he's doing everything he can not to just like burst out laughing. Okay, this is what he does for a living. This is his bread and butter. And Gildea is like, okay, what do you say to that about the Fifth Amendment? And he's like, yeah, no, it has nothing to do with it. I just want to take it back so you can watch this man stand up and command the room as the smartest person in the room with regard to anti-Slapp litigation. He's the guy. Okay, watch.
Defame private citizens.
So, Attorney Pyle, what do you say to the relevance of the Fifth Amendment?
There is no relevance to the invocation of the Fifth Amendment, because he's being sued for his statements that he made well outside of the courtroom. Those statements were petitioned. The suggestion that Mr. Kearney did not intend for his message about Karen Reed's innocence and the plaintiff's guilt to reach the government is belied once again by the allegations of the amended complaint. They admit that Mr. Kearney was responsible for the hundreds of people who showed up at the Dedham courthouse every day during that trial to protest. Who were they protesting? They were protesting the prosecution of Karen Reed. Who was prosecuting Karen Reed? The government. Mr. Kearney is clearly the leader of the national Free Karen Reed movement. And what do the words Free Karen Reed mean? What do they signify other than a demand, a petition that the government do something or stop doing something? That's what he did. Obviously, his words we reached the government. You have in the record, early on, in some of his Canton cover-up stories, a directive to his readers. Email Michael Morrissey at mmorrissey@state.ma.us. That's in one of the very first Canton cover-up articles. He says repeatedly that our presence, protesting and doing standouts, is intended to let the government know that we are watching and that we will not let an innocent person be railroaded. The anti-Slapp statute doesn't extend just to speaking in court or petitioning the government directly, as in filing a police report. It extends, and I know Your Honor knows this, to statements that are reasonably likely to enlist public participation in an ongoing judicial case. I would submit that Aidan Kearney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth.
Do you agree? Do you agree that Aidan Kearney rallied the most public participation in any trial ever in the history of the Commonwealth? What? Spitting facts. And he says, all the stuff that they alleged in their complaint and their amended complaint is 100% true. He absolutely did gather the masses to come and to be interested and to learn and to find out why this innocent woman was being persecuted twice, not once, but twice, for murder, for a car accident that didn't happen, for the murder of a Boston police officer in which no other suspects were even ever investigated. Even the guy who brought in all the text messages with the girl that he was trying to get with, who they're now trying to pin the murder on. Never was even Higgins a suspect. Nobody ever went inside the house. You know who never went inside the house? Not just, they say the guy never went in the house, right? That was their story. Law enforcement never went in the house either. I want to hear that again because it was so excellent. It belongs on a shirt.
In court or petitioning. Anti-Slapp statute doesn't extend just to speaking in court or petitioning the government directly, as in filing a police report. It extends, and I know Your Honor knows this, to statements that are reasonably likely to enlist public participation in an ongoing judicial case. I would submit that Aidan Kearney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth.
Right. Print that. Is anybody going to print that today? I wonder.
So let's talk about whether Mr. Kearney was doing it on his own behalf or for his reading.
Yes.
Plaintiffs suggest that
Whether he was doing it on his own behalf or on behalf of Miss Reed, it doesn't matter. It doesn't matter. He was trying to get people interested in this case because he felt that someone was being unjustly prosecuted in the state in which he lives. Okay, but Gildea's going to, pivot a little bit. Was he doing it on his own behalf or on the behalf of Ms. Reed?
the claims against him, can't show the claims against him are based solely on petitioning activity. And they point to Judge Krupp's finding of an intent to influence and pressure the witnesses, as well as to Judge Dugan's finding that Mr. Kearney's purpose was to interfere, obstruct, and a few other words. So what do you say to that?
Could you hear what he said? Could you hear what he said? Okay. He's whipping out Judge Krupp's ruling and Judge Doolin's ruling. I have Judge Krupp's 11-page decision from 2023. It was an exhibit to something that I came across recently, and it's wild. Judge Krupp and Judge Doolin are judges that are sitting on Aidan Kearney's witness intimidation criminal charges, none of which has he been convicted on. Okay? So it doesn't matter what they say and their decisions. There's no conviction attached to it. So their opinions of what they think Aidan Kearney's intent was is not based on any testimony of his. And I think all of these things were on the papers. I don't think anything had to do with any testimony. And Pyle's got a great answer for this too. He's going to clap right back or slap right back, and that's what we're here for.
Those rulings are not helpful on this motion in the court's task because they turn, as you just mentioned, on the question of intent. And the anti-Slapp law provides that the motive behind protected petitioning activity is not to be considered at the first stage of the analysis, which is where we are. That's been the law ever since the Office 1 versus Lopez case, if not before, back in 2001. And the witness intimidation charges relate to conduct that is only partly part of this case. The witness intimidation rulings by those two judges do not analyze whether Aidan Kearney's statements meet the statutory definition of petitioning under the anti-Slapp statute. Instead, all those decisions say is that there's probable cause to believe that he may have, on the right proof, committed certain crimes that turn on subjective intent. And that is not helpful in the current motion. The current motion looks at statements. The question is whether the statements for which he has been sued meet the statutory definition of petitioning under the anti-Slapp statute, and the question of motive is not to be considered. And that, not to get off the topic of Your Honor's question, but the commercial motive.
We'll get to that.
Okay.
So, Attorney Mattei, tell the line judge.
I love this man. I really love this man. I love this man. He says in the first part of the analysis about whether or not this is protected speech under the anti-Slapp law and legislation, you can't even look at motive. It doesn't matter. You have to look at the statements and about whether the statements are protected as petitioning activity. You have the right to petition your government. You have the right to say things that are intended to petition the government in any judicial proceeding. And I thought that his motion was amazing. I think Jeffrey Pyle's a great writer. I loved reading it. It was like reading a story. It was very easy to follow. It was very easy for lay people to understand. And the argument in the motion is, listen, every single thing that Aidan Kearney said had a reasonable basis in fact. But not only that, he had the right to say it in his petitioning of the government because the likelihood is that it would reach or influence a judicial proceeding. Karen reads criminal trials and then the civil trials.
Judge Cross. Statements are relevant.
So, Your Honor, Judge Doolin and Judge Krupp's findings that Mr. Kearney's activity was outside the protection of the First Amendment because it was activity that was intended to intimidate witnesses and harass witnesses is important because it provides you with some insight as to how other judicial officers considered whether or not that type of conduct was constitutionally protected and therefore likely to be petitioned. In fact, what Mr. Kearney has done and what Ms. Reed has done by conspiring with him is pursued an unlawful campaign of harassment and intimidation, and a tool that they used in connection with that campaign was defamation. And so this, I think, the findings of Judge Krupp and Judge Doolin really just point to a truism. And that truism is, in the history of the United States, there has never been a case that we can find in which the court ruled that one citizen may publicly accuse another of murder outside of any reporting to government and be immune from civil liability for it.
I mean, like you said, or like Jeffrey Pyle said anyway, this case is one of one. This is a unicorn. Okay, you're probably never going to see a case like this again. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. Karen Reed was acquitted. Therefore, something else happened to John O'Keefe. There's a lot of suspicious behavior and a lot of suspicious testimony, a lot of suspicious witness statements, changing stories, time drifting, butt calls, paranormal activity, if you want to call it that, in Canton in the early morning hours of January 29th of 2022, and a lot of reasonable basis to believe that something else happened to John O'Keefe that involved the people in that house. And the reason you can't find a case is because there's never been a case like this before. And those two pretrial rulings by Doolin and Krupp should not apply at all because, again, those are based on the papers. Was there enough reasonable cause to charge Aidan Kearney with witness intimidation? Based on what? Based on what the witnesses said. Aidan Kearney intended to harass me. He intended to ruin my life. He intended to do this and that and the other. Aidan Kearney has not testified. And I'm sure that when his trial comes up in December, he will. But I don't think that Krupp and Doolin's ruling should apply here because there hasn't been a conviction. But go on with your bad self.
There is no case, Mr. Pyle has not cited any case. It would be a radical expansion of anti-Slapp protections for this court to find that. And that is highlighted by Judge Doolin's and Judge Krupp's conclusions that what Mr. Kearney was doing with respect to these witnesses, and again, I think it's important to separate what we've alleged in the complaint, which has to do with conduct directed towards these witnesses, versus other conduct he may have been involved in, relating to the DA or the investigation or whatever it may have been. What we've alleged is a course of conduct directed at these witnesses. What Judge Krupp and Judge Doolin analyzed was the conduct he directed at these witnesses, and they found that there was no constitutional protection for it, which is exactly what we are saying in this case, that there was no constitutional protection for his defamatory and harassing conduct. The defamation here being in service of an effort not to petition the government, but an effort to intimidate and browbeat these witnesses into changing their testimony.
Or to tell the truth. Anti-Slapp legislation does not apply to criminal cases. It only applies to civil cases. And that's why we're here. This is a civil case. So again, what the criminal judges decided his intent was based on nothing more than the statements of these exact people who are now suing him for defamation doesn't hold a lot of water with me. But who knows what this judge will do.
And we make a specific allegation in the complaint in that regard, where Mr. Kearney says, this will all stop if you flip. He's not petitioning the government to get these witnesses to flip. He's petitioning the witnesses themselves, and he's encouraging others to intimidate them in order to create that outcome for Ms. Reed.
So, Attorney Pyle, along that issue, it would appear that your position is that the anti-Slapp statute and the cases interpreting it preclude someone who has been publicly accused of murder by Mr. Kearney from prosecuting an action such as this.
I'm sorry, Your Honor, I don't understand the question. Preclude?
Well, put another way, how can publicly accusing someone of murder be petitioning activity?
Oh, easily. It depends on.
How can publicly accusing someone of murder, hold on, be petitioning activity? And he's going to say, easy. A lot of people think accusing someone of murder is defamation per se. And yes, that used to be the common law in many states. However, if it's connected to petitioning activity, this is why anti-Slapp legislation was enacted to prevent frivolous litigation of people suing other people, corporations too, for saying things that the other person just didn't like. And he's going to tell us why.
Well, put another way, how can publicly accusing someone of murder be petitioning activity?
Oh, easily. It depends on the context in which the statement is made. And I will have to say regretfully that the plaintiffs have broadly overstated the law about this. They say on page 20 of their brief that the law is clear that accusation of criminal conduct is only petitioning if made to the police or other law enforcement agency.
Wow.
That's on page 20 of their brief. There is literally never.
And that's insane. They say that you can only accuse someone of murder if you tell the police or the FBI. You're not allowed to say it to anybody else, or it's not petitioning activity. I'll repeat what the judge says if you can't hear him. How about that? Okay? I'll rewind and listen to what the judge said so that I can explain. I can repeat it for you.
It would appear that your position is that the anti-Slapp
It would appear that your position is that the anti-Slapp
statute and the cases interpreting it
statute and the cases interpreting it
preclude someone who has been publicly accused of murder by Mr. Kearney from prosecuting an action
preclude someone who's been accused of murder by Mr. Kearney from.
such as this.
I'm sorry, Your Honor, I don't understand the question. Preclude.
Well, put another way,
Put another way, because it was kind of jumbled. I didn't know what he said either.
how can publicly accusing someone of
How can someone publicly accusing someone else of murder be petitioning activity?
Oh, easily. It depends on the context in which the statement is made. And I will have to say regretfully that the plaintiffs have broadly overstated the law about this. They say on page 20 of their brief that the law is clear that accusation of criminal conduct is only petitioning if made to the police or other law enforcement agency. That's on page 20 of their brief. There has literally never been a Massachusetts case that has said that. They cite 4 cases in support of that assertion, but none of them say that. And, of course, reports to the police are petitioning, but that doesn't mean that reports that, a statement that the police are investigating the wrong person, who the police should be investigating, are these plaintiffs, Brian Albert, Brian Higgins, Jennifer McCabe, Colin Albert. They should be investigating them. And the fact that they didn't even consider investigating them shows that this police department is corrupt. That's been
Right. They didn't even consider investigating them. And that shows that they're corrupt.
Aidan Kearney's thesis throughout this entire time. In a footnote in their brief, I note that the plaintiffs concede that generally raising awareness about police corruption is and can be protected petitioning activity, they say, but they draw this distinction. Accusing people of murder can't be petitioned. In this case, they are all part of the same ball of wax, because the reason that Aidan Kearney believed that Trooper Proctor and the other investigators were corrupt was because they didn't even consider investigating the people at 34th Ferry on that night in question. Instead, they decided to protect, he said, a Boston police officer and other powerful people in Canton. The corruption is bound up inextricably with the allegation that plaintiffs were responsible for this murder and not Karen Reed. The North American Exposition Company case says that in deciding whether statements are petitioning, you must look at them in a context in which they were made. The context is extremely important. And to say in the abstract that it can never be petitioning to accuse somebody of murder ignores that line of cases. You must look at the context in which this all occurred, the pending judicial proceeding against Karen Reed, Mr. Kearney's campaign to try to ensure that those charges would be dropped and that the plaintiffs would be charged instead. That is the context in which these statements were made. That is a context that contributes substantially to the finding that this was all petitioning.
Well, let's talk about context for a second, because many of Mr. Kearney's actions could be interpreted.
Let's talk about context for a second, he says, because many of Aidan Kearney's actions could be interpreted as
Seeking to make the plaintiff's lives miserable.
Seeking to make the plaintiff's lives miserable.
In fact, he says so.
In fact, he says so.
He said somewhere, I forget where I read that, they'll never live a normal life.
In fact, he says somewhere, they'll never live a normal life. Remember, we watched that whole entire video. Just to remind you, the amended complaint had something like, well, the first complaint had 60 footnotes of all kinds of things, videos that were hours long. We watched and clicked on and every single hyperlink, and we watched every single video in its full context. But of course, the judge is only portioning out a little tiny piece of it, because when we watched the full videos and everything was in context, many of them were very favorable to Aidan Kearney. Okay, he's going to make their lives miserable. Okay.
The plaintiff cites Judge Salinger's decision in Clay Court versus Holt.
Plaintiff cite to Judge Salinger's decision in Clay Corp.
For the proposition that targeting private plaintiffs for punishment is not petitioning activity.
For the premise that speaking about plaintiffs to punish them is not petitioning activity.
What's your response to that?
What's your response to that?
The motive behind petitioning activity, once you establish that it constitutes petitioning activity, is irrelevant. And I would suggest, Your Honor, that it's helpful to look at these allegations on a count-by-count basis. That is what Crystal Asphalt instructs must be done. The defamation count.
You all did that in your submission.
Well, I would respectfully say we did it better than they did, but
Judge is like, you both cited that case and you did a good job in your papers. And he said, yeah, I did a better job than they did because the case is better for me than it is for them. He didn't mean you and Karen Reed's attorney. He meant you and Haas Plaintiff's attorney.
On the defamation count, Your Honor mentioned earlier that reviewing the complaint is the first step in deciding what a claim is based on. That entire claim is set up at paragraph 156. In repeatedly publishing false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in the murder, Kearney published numerous defamatory statements. That is and then they list the harm and the fault and all sorts of other things that they say provide the foundation of the defamation claim. Absent from that is any allegation that he set out to make their lives miserable. Absent from that is any motive allegation, which isn't relevant in the Anti-Slapp context anyway. The statements that plaintiffs were responsible for the murder were part and parcel of his petitioning about the corruption of the case and everything else. That is what the defamation count is based on. And, clearly, we say all the counts are based solely on petitioning. But plainly, they state right there in paragraph 156 that that's the foundation of the defamation complaint. So anything else about notions of motives to make their lives miserable or that kind of conduct isn't relevant to that defamation, which is the central count in this case.
Right.
I do.
He's arguing that even if it is defamatory under the law, if it is petitioning activity, it doesn't matter. It still gets dismissed if it's petitioning activity. Scott, you're very fast on the button today. A little faster than I am. I'm still moving a little slowly from my morning propofol nap. Okay, let's see what Mattei has to say because he's going to jump right up.
I have several responses, if that's all right, Your Honor, in response to what Attorney Pyle was saying earlier. You asked him earlier, why would accusing a private citizen of murder be petitioning activity? And he said, oh, easily. And then he didn't cite a single case in which that has ever been found. That accusations against another citizen, not funneled to the government, not a police report, not a tip to the FBI, not using an intermediary to inform law enforcement that somebody has committed a crime.
Yeah, that's a great idea. Let's go to law enforcement and have them investigate their own. That's a great idea because it worked out real well. Worked out real well for whoever it is that murdered John O'Keefe and or covered it up because they were never investigated because the law enforcement is corrupt. You see how that works, Mr. Mattei? I know you're from Connecticut and you might not be familiar with the decades and decades and decades of corruption in Massachusetts, but the people in the chat here will tell you, and there's almost 10,000 of them, many of them from Massachusetts. This has been going on for decades. There's never been ramifications for any of the behavior of the corrupt law enforcement. And so who is going to go to the police? You know who they go to? They go to journalists like Aidan Kearney to tell their story because they're afraid of the police because the police are not there to protect them. They're there to protect each other. Okay? Go on.
Just speaking it, that another citizen has committed murder falsely, as you have to presume in construing our complaint. He says easily that's petitioning activity, and yet nowhere in the history of the Republic, as far as we can tell, has any court ever concluded that. In fact, to the contrary, we cite cases where, as Attorney Pyle says, petitioning activity is found where citizens report criminal conduct to law enforcement. But in those same cut cases, and I would urge you to consider Bowman, which is a First Circuit Court of Appeals case. Those same cases acknowledge that the reporting of criminal activity to law enforcement is petitioning activity, but then reporting of it to third parties is not. And in that case, the plaintiff was somebody who had been accused of sexual assault. The accuser had previously made a complaint to the FBI and another governmental agency. Subsequently, she informed people with whom that individual was doing business of the same complaints. And the First Circuit concluded that while the earlier reports to law enforcement may have been petitioning activity, the reports to third parties were not. And here's the kicker. The reports to the third parties were to staff of congressmen. And even there, the First Circuit held that that was not petitioning. And there are other cases that we cite in which wrongdoing is reported outside of governmental channels and not given petitioning protection. I want to talk about Attorney Pyle's comment about context, that it's important to consider context. They cite North American expositions for that principle. We cite it as well. The context that the court was considering in North American expositions wasn't the political climate. It wasn't the overall course of conduct. It wasn't, some atmospheric assessment of what was going on in the world. It was the context of the forum in which the statement was made. And there, the forum in which the statement was made was to the South Boston Community Foundation, which was created by the legislature, placed in the executive branch, and responsible for distributing public funds. And that was the context that North American expositions, which they cite, concluded was an appropriate forum in which petitioning activity occurs. Here, what they are encouraging you to do is say, Judge, consider the gestalt of what Mr. Kearney was involved in. Consider that he was in, as a general matter, using his YouTube page and his for-profit entity to talk about issues.
They're so jealous that he makes money. They're so jealous that he has rallied a whole bunch of people who donate to him and give him money and he makes a living. They're so jealous of him. It's not a crime to make a living. Everything that he said has a reasonable basis in fact. Okay. And there's 9,907 reasonable people here in the chat. And I'm sure that you were not brainwashed by Turtleboy. Many of you were not even familiar with Turtleboy when you came to the conclusions that John O'Keefe was not hit by a car and a car did not hit John O'Keefe, and therefore something else happened to them. And there's a lot of suspicious behavior about these people. If you were brainwashed by Turtleboy, raise your hand. But they're real mad that he made money rallying people into this, as they say, largest movement that the Commonwealth of Massachusetts has ever seen in the history of a court case. And that people care about it.
The context in which you should find that his accusations against private citizens of murder were petitioning. No, that's not what the cases say. The cases say, the North American expositions in particular says, that when considering context, it is the forum in which the statements are being made. And I think that that's a crucial distinction. I do want to say...
Good, keep that in mind. Keep the forum in which the statements were made argument in mind when you get to Karen's statements to Terry Moore, the documentarian, that were never aired to the public, that are on the cutting room floor somewhere, and that you did not cite to in your complaint. So nobody has even seen what it is exactly that you're talking about. So keep that in mind. Because Karen Reed made those statements allegedly to the documentarian of a documentary that was supposed to be pro Karen Reed. And those pieces, I think, that you cited never aired. If I'm wrong about that, please tell me. But somebody went back and watched that entire Body in the Snow documentary, and none of that stuff that they cite in their complaint was aired. And we're going to go back and look at it after the hearing.
One other thing in response to Attorney Pyle.
Just one.
I can wait as well, because I know you came out asking questions, and I don't know whether, Judge, at some point you want to, whether we should make more expansive remarks, but I'm happy also if you have something that you'd like to key in on to the point. I wasn't quite, now I lost my train of thought. Oh, I think it had to do with intent and motive. It is absolutely true that the court should not consider Mr. Kearney's motive at this point.
Okay.
And yet, Mr. Kearney in his memorandum spends pages and pages and pages telling you that he was motivated by a sense of justice, that he was motivated to shed a spotlight on this criminal justice proceeding, that his motive was to spur others to action. None of that.
And it worked. It worked.
Matters. Even if true, it doesn't matter.
It is true.
What matters is...
You know why it's true? Because you said it in your complaint. You said all of that in your complaint. That because of what he was doing to your poor plaintiffs, There were hundreds of people outside the courthouse, and there were hundreds of people driving by their house in a rolling rally, and the people were mobilized. You said it, and he agreed. Yeah, that's all true.
What he did, and whether there is objective indicia of his intent. So his self-professed motives here, and the same with Mrs. Reed, don't matter.
When did Mrs. Reed get married? Is he talking about Janet Reed? Because the last time I checked, Karen Reed wasn't married.
What matters is whether the record, with respect to the statements he made to our clients, presents objective indicia as to whether what he was doing was intended to reach the government. And here, what we say is that the objective indicia, the fact that he never actually reached out to the government, the fact that he declined an opportunity to do so, the fact that he encouraged his audience to use...
That he declined an opportunity to testify in Karen Reed's criminal trial? About what exactly? They were never going to call him, and you know that. And you know he's entitled to Fifth Amendment protection. So it's a bogus argument, and I have secondhand embarrassment.
Coded language to defame the plaintiff.
Coded language. Can anyone point me to the coded language that Turtleboy told his viewers to use? The coded language. Listen to this.
The fact that he declined an opportunity to do so. The fact that he encouraged his audience to use coded language to defame the plaintiffs. Coded language, meaning language that by its very nature would obscure the government from knowing what he was doing.
It was a joke. And if you're talking about Turtleboy was right, why won't you say the coded language? Because you don't even want to say it. It's like saying Beetlejuice. It was a joke. We watched the whole entire video. It's not like he's it's not like he's Mackenzie Shirilla on a jail call. Okay? It's not that. It's Turtleboy was right. It was a joke. There's shirts. There's merch. I think we should buy one for Mr. Mattei. Send it to is up. No, don't do that. Really? Coded language. Okay.
The fact that he engaged in private confrontations suggests that there is an objective indicia that he was not looking to reach the government. That's what matters, not his after the fact self-comparison to Oliver Wendell Holmes. What matters is the objective indicia in the record as to what he did.
So don't worry, we'll get to it at some point.
Private confrontations? Who did he confront privately? You mean the one time where he was outside D&E Pizza and they attacked him? The private confrontation of intimidating the window with the T-Rex arms? The going to the Bill Ricca lacrosse game? What exactly? And that wasn't private because that was at a lacrosse game. And then the judge just said, Mr. Seligson, don't worry, we'll get to you, because he just jumped up. Let's go, Pyle.
So, Attorney Pyle, let's talk a moment about public participation. When I read your filings,
Let's talk for a minute about public participation, Mr. Pyle. When I read your filing,
get the sense that there's a little bit of overreach.
Get the sense that there's a little bit of overreach. You can see Judge Gildea. He looks like a little tiny Jesus all the way back there, because nobody ever gets a tight shot of Judge Gildea, ever. This is Tiny Mary, but you get the point.
And it's supposed to go to any statement reasonably likely to encourage consideration or review of an issue. The language goes on, but how is posting to social media or encouraging people to...
He hates social media, this judge. How is posting social media or encouraging people to participate in a rolling rally
at plaintiffs' homes, the type of public participation
at plaintiffs' homes
contemplated by the statute?
And public participation contemplated by the statute. This judge hates social media. He doesn't understand it, maybe.
There have been a number of anti-Slapp cases that have turned on use of social media to inform and mobilize other people. I had the very first one. It involved the plan to build a racetrack.
He had the very first one, the very first case, the very first anti-Slapp case to involve social media was this man's case. Okay. Excuse me. Do you know who you're talking to? Do you know who he is? He's the guy. He's the father of Anti-Slapp. He's the guy that all the media goes to when they want to argue free speech. He's the man. It was his case. He knows it pretty well. Let's hear what he's got to say about it.
In the Plainridge Casino, and the Superior Court there held for the first time that posting on Facebook is protected by the Anti-Slapp statute. Posting on social media is the way today in which people connect with each other. Aidan Kearney has done that to great success in getting people involved in these issues. Indeed, posting on social media and posting on the internet generally, I would point out, is what led your affiants Rita Lombardi and Paul Cristofaro to do things that are clearly public petition, going to Canton Town Meeting, going to the State House. Mr. Kearney, by the way, this...
And they both, Rita Lombardi and Paul Cristofaro, signed affidavits in support of Aidan, in which they said, anti-Slapp daddy, motion granted, in which they said, Turtleboy's the reason we got involved. He's the reason that we went and fought for an audit of the Canton Police Department. He's the reason. He's the guy who was screaming with the bullhorn, and that's why we got involved. It's very powerful, if you ask me.
Suggestion has been made, Mr. Kearney never going to the State House. Mr. Kearney, by the way, the suggestion has been made, Mr. Kearney never petitioned the government on his own, but they allege in their amended complaint that he was there protesting at the Devon courthouse. He was also up at the State House protesting to get the Attorney General involved in all of this. He decided that his words, his direct police report from Aidan Kearney to the Canton police wouldn't have done anything. He wasn't a witness to this murder. He reasonably determined, the facts would show, that mobilizing thousands of people to protest against this unjust prosecution would be a way, potentially, to get the charges dismissed as he believed they should have been, by putting pressure on elected officials to do so.
Right.
That is core protection.
Encouraging people to participate in a rolling rally.
But encouraging people to participate in a rolling rally?
The rolling rally, Your Honor, is very much participation and likely to lead to further public participation. That was a caravan of cars that started in a supermarket parking lot, went to various people's houses, didn't stay for too long, ended up with a protest in front of the Canton Police Department. That is I recognize that he's been indicted for that conduct, but it was a peaceful protest in cars, and Mr. Kearney is vigorously fighting, of course, the criminal prosecution for witness intimidation that arises out of that rolling rally. It was also heavily promoted online, such that people who weren't there could see, look, there's lots of other people who believe so strongly in this cause. They're going to go out on a sunny day and participate in a public event. That is also reasonably likely to enlist further public participation by others in this cause.
And by the way, the police knew that it was happening. They set up cameras so that they could record it. And if they wanted to, they could have stopped it, but they didn't, because it is petitioning activity. As the curl turns, it is textbook petitioning activity, peaceful protesting.
It is part and parcel of the petitioning activity in the case, and it meets the statutory definitions. Also, he's been sued, once again, for statements accusing plaintiffs of murder, statements that were made in connection with the ongoing criminal case. There's not just one element of the anti-Slapp definition we're relying on. We're also relying on the statements that, at least during the entire time of the Karen Reed prosecution, his statements were made in connection with the pending judicial proceeding and were intended to reach the government directly or indirectly.
Let me turn to a few questions relative to the Reed motions. First of all, whenever you start arguing, I don't need to have the party spending time with 12B6 party. I can review.
Okay, now he's going to turn his attention to Karen Reed's motion, and he said, "By the way, I don't need you to argue 12B6. A 12B6 motion is failure to state a cause of action. It's made typically in every civil lawsuit right away saying on its face, your complaint does not allege a cause of action against me and therefore it should be dismissed. Both motions were made. The anti-SLAPP. SLAPP is strategic litigation or strategic legislation against public participation. That's what it stands for. Anti-SLAPP, strategic legislation against public participation. He says, don't waste your time on that. I just want you to confine your arguments to anti-SLAPP. And now Seligson is on the hot seat.
The four corners of the complaint or the other complaint, I guess whatever complaint I determine is the operative complaint. And I'll consider your written submissions. But we start with the plaintiffs. Would you not have responded to the issue raised in the June 23rd amended motion to dismiss, or requested from the court more time to do so?
Your Honor, we do respond to.
Okay. I thought that was a question for Seligson. So he's like, why didn't you respond to the amended motion? Wait, hold on.
To the June.
Amended motion to dismiss, 23rd amended motion to dismiss, or requested from the court more time to do so.
Why didn't you oppose the amended motion to dismiss and or request more time? Remember, there's a question about whether, and they didn't, from the papers that we saw, Karen's team did not address the allegations in the amended complaint that have to do with Terry Moorer, that documentarian who did the Body in the Snow docuseries, who had access to Karen Reed's team throughout trial number one, pre-trial number one, and I think it aired after trial number one. It was supposed to be a pro Karen Reed piece that turned into like a hit piece because for some reason the documentarian turned against Karen Reed. And so I thought this question was for Seligson, but Mattei jumps up to answer it.
Your Honor, we do respond to the June 23rd motion to dismiss. It's our position that the opposition that we filed following service of both the June 18th and the June 23rd motions to dismiss address both of all of the issues raised in both of them. We didn't feel that we needed more time to respond. In fact, we thought that the appropriate course.
But you take the position that I shouldn't consider amended motion, the second motion.
Well, we do. I mean, we think it was a violation of the rules for them to serve it out of time without permission from the court. We think that it didn't comply with 9C. We think there are a whole host of reasons why the court shouldn't consider it. But if the court were to consider it, our opposition, which was served after we received service of both that and the June 18th motion, apply to both.
You took the time to.
All right. So Karen Reed filed a motion to dismiss. And then the opposition said, wait a second, your motion to dismiss was directed at the wrong complaint. Because what had happened was they filed their initial complaint. I wrote it down somewhere. Now I don't remember where I wrote it down. Their initial complaint, I think, was filed in April 16th, 2026 was their original complaint. It was filed in Barnstable, and then it was hand-plucked out of Barnstable by the Chief Justice and moved to Plymouth. And then the amended complaint was filed on June 5th. So April 16th and then June 5th. Karen Reed's team filed a motion to dismiss based on the first complaint, not the second complaint. But you know, if you've been watching me long enough, that an amended complaint supersedes the pleading. And so the amended complaint is the complaint that governs here. And you're allowed once as of right to amend your complaint. And so Karen Reed's team, when it was pointed out, or they realized their motion was not directed at the amended complaint, which included a lot more stuff and different paragraph numbering. And remember, when we went over it, we went over the motion, the complaint and the amended complaint side by side. And I told you exactly what was new, exactly what was different, and why. He's saying that they amended their motion, but they didn't ask the court's permission to amend their motion. And so we didn't have to accept it because it was outside maybe the 7 days. Maybe it was 10 days instead of 7. And so we didn't have to accept it. And then the judge is going to be like, why didn't you come to me and ask for permission? And meanwhile, the judge has been asking everyone to stop bothering me and try and work it out amongst yourselves. And he's going to say something that I'm going to stop because I couldn't believe he said it. the judge. So listen. Yeah, apparently he's saying Karen Reed's team should have came and asked his permission to amend their motion when they realized that their initial motion was geared towards the original complaint, which is kind of a rookie mistake. Like the amended complaint is what governs here, not the original complaint, but a mistake was made somewhere and it had Barnstable on the caption. It was, I don't know what happened. And it was numbered like 1, 2, 1, 2, 3.
Have an affidavit submitted, which included a copy of the June 18th motion to dismiss.
Yes, we did do that.
So I think the first motion was June 18th.
I mean, I'm not sure I understand
Well, then,
the suggestion.
why did you do that if you responded to the June 23rd?
Well, Your Honor, we thought it was important.
So they filed their first motion on June 18th. And it sounds like they filed their second motion on June 23rd. And the judge is like, well, why did you respond to their second motion then? If you had a problem with them responding to this, I don't know. It's like pulling teeth.
Important to bring to the court's attention what we consider to be Ms. Reed's gamesmanship with the rules of procedure. So
Gamesmanship with the rules of procedure. This is what we're dealing with here. Okay. Here's the thing about civil litigators. Okay. I was one for over 30 years. Cases come and go, but I was a plaintiff's lawyer. I have friends who are defense attorneys. You come up against the same defense attorneys all the time. It's a relatively small pond. Many defense attorneys work for insurance companies. And so if you have a car accident case and Allstate is the carrier, you're going to have the same attorneys all the time for decades. And so typically, you grant each other courtesies. Not here, not now, not in this case. And I don't know if it's a function of the clients not allowing their attorneys to grant courtesies. I don't know what the deal is, but they talk about gamesmanship. We saw Cosgrove yesterday. That was a criminal case, but no, it was a civil proceeding to get her phones back. Cosgrove pulling out Judge Cannoni's, lambasting of Alan Jackson, and he's a liar, and she said so, and he's unethical because she said so. You don't see things like this very often, and it's disheartening to see.
she serves on us a motion.
That's why you did it, all right.
Yeah, that's why we did it.
So, Attorney Seligson, apparently the original motion to dismiss that was served addressed the plaintiff's original complaint, not the First Amendment complaint. Is that correct?
The original.
He's like, Seligson, apparently your first motion to dismiss, like I said, only addressed the first complaint, not the amended complaint. Yeah, is that right? Mm-hmm.
Motion addresses the complaint, which is extended
No.
by an amendment.
Hang on.
He's like, no, hang on. I know my rules of procedure, judge says.
It would appear, from what I saw, that, and I'm happy to give you, because I did compare and contrast of your original motion.
Yes, Your Honor.
He's like, I'd be happy to show it to you because I did a compare and contrast of your original motion. So the judge did what I did, and he put them side by side so that he's like, I'm going to tell you what's wrong. This is like all about procedure now and not about the rule of law. And this really should be about the rule of law, but you need to follow procedure too, right? You need to do both.
And the second one, but
Oops.
what it appeared is that maybe someone responded to the wrong complaint. I don't know. But after
What it appears to be, the judge says, is that it seems that somebody responded to the wrong complaint.
the issue was brought to the attention, your attention, or whoever in your office, you unilaterally file an amended.
But after the, the mistake was unilaterally brought to your attention, or whoever it is in your firm that was drafting the papers, you unilaterally just filed an amended motion without asking my permission.
On June 23rd, and Attorney Mattei references 9A. I might have missed it in 9A, but I don't quite see how you get to do that.
Well, Your Honor,
I don't quite see how you get to do that, because I don't see that in your 9A papers, the package that they file with the motion. Like, I don't see where you came to me and asked for my special dispensation to do that.
the June 23rd motion to dismiss simply corrects the caption.
But it's.
But Your Honor, if I may
rule
answer the
doesn't-
question.
The rule doesn't allow it, does it?
Yes.
Does Rule 9A allow me to send a motion and then a few days later say, yeah, I changed my mind, here's another one?
Nothing was changed.
He's like, the rule doesn't allow that. Where does it say in the rule that, you know, you can file a motion, then a couple of days later I just changed my mind, I'm going to file another motion.
We didn't change, no one changed their mind, Judge. What happened was there was an amended complaint which simply adds additional factual allegations. There's no
But
new.
why wouldn't you ask for permission? Why did you just do it?
Because we thought we could
Why wouldn't you ask for permission? Why'd you just do it?
reasonably deal with counsel. That's why, Judge.
Right, because most attorneys grant courtesies, like I said.
And I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process, and I just don't know. It just seems to me this decision such as that, just, I don't know whether it's a,
Wait, here it is. He says,
why did you just do it?
Because we thought we could reasonably deal with counsel. That's why, Judge. And I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process.
there's prejudice to the process. Meanwhile, how many times has he been screaming, work things out amongst yourselves? I want you all to come to a reasonable gag order. And if I say it's good, I'll sign it. Now he's talking about prejudice to the process. Different case. That was in O'Keefe versus Reed. This is Haas Plaintiffs versus Karen Reed and Aidan Kearney. But listen to what he says next. You might want to turn it up.
And I just don't know. It just seems to me this decision such as that, just, I don't know whether it's a showing of entitlement or arrogance. I don't know which it is.
Seems to me that a decision such as that, I don't know whether it's a showing of entitlement or arrogance. I don't know whether it's a showing of entitlement or arrogance. This judge has taken every opportunity to publicly disparage Karen's attorneys. And that, my friends, is not common. It's just not really done. I mean, we saw it a lot with Judge Kearney. I take that back. We saw it a lot with Judge Kearney, again, with Karen Reed's attorneys. I don't know whether it's arrogance or entitlement. That's a wild thing for a judge to say. And it shows bias, in my opinion. And look at Damon Seligson's face. He's like, where am I right now? We need some like Twilight Zone emojis in the chat. I mean, this is the inside out, upside down Narnia of Massachusetts. It doesn't happen. Okay, let's hear that one more time. Let me see if I can. You might have to just turn it up on your end.
Reasonably deal with counsel. That's why, Judge.
There it is.
And I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process. And I just don't know. It just seems to me this decision such as that, just, I don't know whether it's a showing of entitlement or arrogance. I don't know which it is.
It's neither, Judge. It's simply correcting a motion to dismiss.
A showing of entitlement or arrogance. Tell me if I'm overreacting. I tend to do that sometimes. People think so anyway.
A complaint that was subsequently amended that has absolutely no change substantively, no change in parties, counts, theories, or anything other than additional facts, which we address in reply. So it's a correction of the original motion. We reached out to counsel after they pointed it out to us. Asked them
They
if,
told you they weren't going to accept it.
well,
So you decided, okay, I don't care what they say, we're just going to do it.
They told you they weren't going to accept it. So you were just like, okay, well, I'm just going to do it anyway.
how are they prejudiced? We even offered them more time to respond to it. It's form over substance, Judge, with all due respect. The arguments are still presented. The theory that they're advancing is still addressed. There's no prejudice. There's no change except some number paragraphs. And where it said Plymouth, it had said Barnstable because this is where the case originally originated. So while I understand the mechanics of the process under 9A, we really haven't violated anything. We've responded to the amended complaint, which is purely an extension of the original complaint. There's cases that hold for that position. It's not an inoperative, superseded complaint. It's an extension of what was initially filed. And we've addressed the arguments.
It was filed as of right. So that's the operative complaint. The amended complaint was filed as of right.
He says, and he points out the amended complaint was filed as of right. And so that's the argument. But here's the thing. I would agree with the judge if and only if in the amended motion, all of a sudden, Damon Seligson started responding to those Terry Moorer allegations, right? Because that would be substantially different than the first motion, right? But he didn't do that, to his credit. He didn't do that. He says what he did was just renumber the paragraphs because, as we said, the paragraphs changed in the amended complaint. And essentially the arguments were the same and the case law was the same. We just changed the caption from Barnstable to Plymouth and renumbered the paragraphs that we were referring to. But had he all of a sudden started refuting those allegations of the document about the documentarian, then I would say that the judge is right. But I mean, this is exasperating. It's a great word for it, Sam.
But it still extends what was initially pled at the initiation of this lawsuit, which is a theory that has not changed by virtue of an amendment. What happens in the amendment is some additional factual allegations are included.
So why didn't you respond? Why didn't you address those in your June 23rd, for example?
Now he's going to get into the documentarian. He says, okay, so then why didn't you address those in your amended motion? It's like, you can't use it as a shield on a sword, Judge, right?
Addressed in the reply, Your Honor.
Right, but you could have done it. You could have done it in the amended motion, couldn't you? Because the reply is not to argue stuff you might have missed. The reply is to talk about new stuff.
But we are under no obligation to address every single factual allegation.
You're not, but you're also under.
I haven't seen the reply, but he's saying we have no right. You know, he's like, well, you can't just bring up new stuff in your reply. Well, that's kind of funny because we just saw it in the other case where in the reply to the emergency motion to continue Proctor's deposition, all of a sudden Proctor's attorney brought in some other tweets that was new information that were not tweets that they had originally, and the judge considered that. So again, his rulings are not consistent. And when a judge is not consistent and you just don't know what to expect, it's very disconcerting.
You don't have the ability just to throw in a reply because you want to put in something you might have forgotten to address.
You don't get the ability to just throw in a reply, something you forgot to address. I haven't seen the reply, so other than that, I can't really comment other than to just repeat to you what the judge is saying.
The purpose of a reply is to reply to the arguments that are in the opposition to the motion to dismiss, which is what we've done. And I'm here to argue it verbally as well.
Let's talk then for a moment about the reference to the statements that Ms. Reed made in 2024 to Mr. Muir.
Yes.
Let's talk for a minute about the statements that Ms. Reed made to this documentarian in 2024. And he keeps calling the person Mr. Muir, but we know that Terry is a woman.
And you address that in a reply. First of all, your reply uses the word allegedly.
First of all, he says, your reply uses the word allegedly. You don't respond to these allegations that she said, the facts. The judge is now taking this as fact, that she said all of this stuff to this documentarian Terry Moorer. He says, first of all, you say allegedly. Are you denying that she said these things?
Describing Ms. Reed's words. Do you not concede that she said those things?
Do you not concede that she said those things? Again, this was called The Body in the Snow. I forget how many parts it was. They had followed Karen Reed's team around, I think, pre-trial and through trial number 1. It was released after the mistrial. And again, I think that none of this stuff aired on television and none of us have seen it. And so when Damon Seligson says she allegedly said these things, despite the 65 or 70 footnotes that the plaintiffs have in their complaint and amended complaint, this particular section is not footnoted at all. There's no attachment. There's no link to the video where she said it. There's no link to an alleged transcript where she said it. And we're going to look at it after this because I thought I was going insane. But the judge wants Damon to address this in open court. Why are you saying that she allegedly said these things? Are you not conceding it?
Well, the alleged is behind what the purpose.
It says her alleged words. That's what your reply says.
It says her alleged words. That's what your reply says. Did the judge watch Body in the Snow? I really want to know. Because the judge did find out about her Today Show appearance and he knew exactly what she said on the Today Show appearance. So I want to know if the judge got Body in the Snow and where it lives, and do you have to pay for it?
Your Honor, I haven't seen the documentary, so I am responding and advocating for my client's argument. So I'm not going to admit that that's what she said until I've seen it. So for the purposes of argument, I must have used the word allegedly.
And he should have said that. He should have said this is the one section of their amended complaint that has no footnote. It has no citation. They're not telling me where they got it from. I didn't watch the documentary. And I'm pretty damn sure she never said any of that stuff and that was aired. It was cutting room footage, cutting room floor footage, and listen to how Mattei's going to argue that.
But the arguments are that that is petitioning activity.
Let's take a look at paragraph 33
of the complaint.
Let's take a look at paragraph 33 of the amended complaint. Let's.
And
Paragraph 33 of the amended complaint, Your Honor.
yes. And that's where the plaintiff's alleged Ms. Reed was the source of a blog post. And where she says Jen McCabe was the mastermind of the cover-up and Colin had motive to kill.
Okay. Paragraph 33, because I'm looking at it right in front of me, is April 18th, 2023. Kearney published the first of two parts of his Canton cover-up series, his first blog post. And it says that Jennifer McCabe would have been the quarterback of the cover-up.
Where she says Jen McCabe was the mastermind of the cover-up and Colin had motive to kill him.
Jennifer McCabe was the mastermind of the cover-up, and Colin Albert had motive to kill him.
Mr. O'Keefe, and I use that particular paragraph just as an example. My broader question is, how are Ms. Reed's statements to Mr. Kearney, not things in court filings, but her statements accusing the plaintiffs of murder?
How are Ms. Reed's statements to Mr. Kearney? To Mr. Kearney?
Mr. Kearney, not things in court filings, but her statements.
Not things in court filings, but her statements to Mr. Kearney.
Accusing the plaintiffs of murder.
Accusing the plaintiffs of murder.
Petitioning activity.
Petitioning activity. How are Karen Reed's statements to Kearney accusing the plaintiffs of murder? Petitioning activity. I'm sorry. My head's going to pop off. This is wild. Paragraph 33, like I said, is about Aidan Kearney's first article that he ever wrote on this case. That is the first time he ever started reporting on this. And they allege in their complaint that although not identified at the time, these sources of Aidan Kearney's were Karen Reed and her legal team.
We'll put another way.
Somebody else or others were. That's in connection with.
I don't know why that just jumped.
We'll put another way.
Somebody else or others were. That's in connection with that judicial proceeding. That's protected petitioning activity. The complaint rests solely on that type of language. It's also, knowing that Mr. Kearney obviously has a wider audience, is arguably to enlist participation. So at least 2 statements of the anti-Slapp statute would cover those statements. From day one, she's taken the position it wasn't her. She was prosecuted twice and acquitted.
Preach.
Let's go back for a moment, if you could, to Ms. Reed's statements to Mr. Muir.
Yes, sir.
She suggested you reply.
He says, let's turn back to Ms. Reed's statements to Mr. Muir. Are you suggesting in your reply?
Within the scope of the anti-Slapp statute. One of the categories being encouraging consideration and review, reasonably likely to enlist participation.
One of the categories of anti-Slapp is statements made reasonably wanting to increase public participation.
So, in the criminal trial, the case went to the jury on June 25th, 2020.
So in the criminal trial, the case went to the jury on June 25th, 2024.
Correct?
Yes.
Okay. 3 days before, on June 22nd.
Okay, 3 days before, June 25th, on June 22nd is when she made these statements to the documentarian in an interview.
2nd, 2024, Ms. Reed gave an interview to Mr. Muir, correct?
Correct.
Gave an interview to Mr. Muir. We know it's Ms. Muir.
Let's look at paragraph 97 and 98.
Let's look at paragraph 97 and 98. Which I'm going to read to you now because we can't hear the judge. 97. On June 22nd, 2024, Reed stated in an interview with Mirror that, quote, I know Brian Higgins had a role in helping kill him, help him get him in the snow and help frame me, but I don't think that Higgins necessarily would have wanted to really hurt John. And then there's some ellipses in there, you know, like the ... meaning that it's not a complete sentence. I think Brian Albert and Colin Albert would have enjoyed roughing John up. Paragraph 98. Further, during the interview, Murr asked Reed, you make such strong statements about, I think Colin Albert killed him. I don't know, without getting sued, because I don't even know if I hope we're going to be able to use some of that because it's public record what you said. Reed responded, if Colin can prove that I'm lying and this is defamatory, he can sue me. I mean, is the judge now going to use Karen's challenge to sue her against her? It's wild.
And in there, Ms. Reed states, among other things, I know Brian Higgins had a role in helping kill him, helped him get him in the snow, and helped frame me. And then Mr. Muir asked Ms. Reed, you make such strong statements about, I think Colin Albert killed him. I don't know how without getting sued, because I don't even know if you're gonna. And Ms. Reed responds, if Colin can prove I'm lying and this is defamatory, he can sue me.
Right.
So my question is,
He's going to have to prove that she was lying. Problem is, he joined the army. He's in the army now, like Conrad Birdie.
how can statements by Ms. Reed outside of her criminal trial, 3 days before the case went to the jury, to your own words, a documentary filmmaker, that apparently were not going to be released to the public at that time, be considered petitioning activity?
How can it be petitioning activity when she was discussing this in an interview with the documentarian 3 days before the jury even had the case, and it was not going to end? It was not going to be aired before the case was over. How is that petitioning activity? I don't know. Do I have to draw a roadmap? The whole purpose of her doing this documentary and giving them unfettered access to her and her team was petitioning activity, was so that the public would know when this thing aired that she didn't do it, that the wrong person is being persecuted, that John O'Keefe was not hit by a car did not hit John O'Keefe, and that someone else did, and they didn't even look at anybody else. The entire purpose of her doing that documentary was petitioning activity. Am I oversimplifying that?
It's almost the claims that statements to the filmmaker are petitioning activity appears to presume that Ms. Reed was either seeking to influence the jury or she knew there was.
He's saying the statements to the documentarian mean that either she was trying to influence the jury or
Going to be a hung jury. How could it possibly? Or she knew there was going to be a hung jury.
or she knew there was going to be a hung jury. Either she was trying to influence the jury or she knew there was going to be a hung jury. Okay, the bias is palpable because now what you're doing is sort of side-eyeing a jury tampering vibe, right? You just said yourself it wasn't going to air. The jury's not supposed to be watching anything, just like you're not supposed to be doing any outside research, Your Honor. How can she be intending to influence the jury when none of this stuff made it into the finished product and or she knew it was going to be a hung jury? No, this is what she believes really happened. This is wild. This is wild.
How could it possibly be petitioning activity?
Well, first,
How can it possibly be petitioning activity? And they takes off his glasses like he's just made a great point. Go for it, chat. Go for it.
the criminal trial is still ongoing. The jury hasn't got the case yet. The jury hasn't decided. So the judicial proceeding is still ongoing. And if we actually look at what happened, there was a mistrial, which leads to...
Just said for Mr. Muir to release those statements?
I'm sorry?
The intent was for Mr. Muir.
Was the intent for Mr. Muir to release those statements prior to the hung jury?
To release those statements prior to the jury?
Well, I don't know what the intent was with respect to when this documentary was going to be released.
Sure as hell wasn't going to be released in 3 days, was it?
Sure as hell wasn't going to be released in 3 days, was it? Can you guys hear the judge, or does it help for me to repeat it? No, sure as hell wasn't, because it was all raw footage and it had to be edited. I don't remember exactly when it did air. I'm going to look it up.
Well, even if it's going to be released in the future, she ultimately is still in the process of being prosecuted.
And
The trial
sued.
hasn't ended. It's still under adjudication. It's still a proceeding. These are still statements. These are still protected petitioning speech, regardless of what Mr. Muir's intention was or when he was going to release his documentary. But ultimately, there's a mistrial, and she's tried again and has the same defense, and that leads to an actual acquittal. So this is also to enlist participation. This is also in connection with the judicial proceeding that's ongoing, and therefore falls squarely into the statute's definition.
If it's made 3 days during a pending criminal trial, made 3 days before the case is going to go to the jury.
It's made during a pending criminal trial, 3 days before the case is going to go to the jury.
And how is it made to enlist public participation?
And how is it made to enlist public participation? Because at some point, Your Honor, this documentary was intended to be released to the public. But here's your other problem. If everything that they said in their amended complaint never made it to the public and only made it to the ears of the people in the room, including Terry Moorer and her crew, where are the damages? Because the only people that publish these statements publicly are the Haas plaintiffs. How are they damaged by that? They're not, because the documentary company chose not to air them.
In the future, because there's, or at the time, it's still part of a judicial, if you take aside the public participation enlistment aspect of the statute, it's still in connection with the judicial proceeding. Whether or not the documentary was published that night, that morning, or 3 weeks from then, it's still in connection with the judicial proceeding. It's still petitioning activity. The statute doesn't say when the judicial proceeding has to have concluded by. It says in connection with the judicial proceeding. Taken to its logical conclusion, it might be that she's even been hypothetically speaking, convicted, and she can still say those things and argue it's in the anti-Slapp statute protection, because it's in connection with the judicial proceeding.
So plaintiff want to respond now?
Yes, Your Honor, I do. What Ms. Reed's counsel has just suggested.
Thank you, Savvy Areas. I just looked it up. So episode 1 of this was 1, 2, it was 4 episodes. Episode 1 was released on St. Patrick's Day, March 17th, 2025, right before the second trial began. And looks like it was released over a couple of days, like March 18th was episode 4. It was episode 5. There were 5. And then March 19th of 2025 was episode 5. So there were 5 episodes altogether. And none of this stuff aired. How do we know? Because Mattei's about to tell us.
Is that there is no limit. There need be no nexus between what she says and the likelihood or the plausibility that it will reach a governmental body. He just said that even post-conviction, and we actually have allegations that she made defamatory statements, both she and Mr. Kearney, post-verdict. But what they're saying is even post-verdict, because she in the past had been subject to a criminal prosecution, she is free to defame people, no matter the audience.
If she was convicted, she would have the right to proclaim her innocence. And if she's acquitted, she has the right to proclaim that other people were never suspected and she didn't do it because she didn't do it. And so other people did it and nobody's paying attention because she wants people to pay attention. And she wants the right people to be tried and prosecuted for the murder and cover up of the murder of her dead boyfriend, Boston Police Officer John O'Keefe. Is that so hard to grasp?
Just because she's commenting on somebody else's guilt, not her own, somebody else's guilt. Blakesley says exactly the opposite. Blakesley says that this court is required to assess if a plausible nexus exists, and in doing that, analyze the objective indicia of a party's intent to influence a government proceeding, such as the timing, audience, and content of the statement. That's exactly what you were just trying to do here. With respect to the murder allegations, the audience of Ms. Reed's statement to Ms. Murr is not the broader public.
Oh.
She's saying that in a closed private room to Ms. Murr and the small production staff around her. Now, if that statement is later published, she...
Okay. So you're telling us everything. It was never published. It was only, she only made those statements in front of Terry Muir, the documentarian. It was on Discovery ID, HBO Max, by the way. I think that's where it lives now. And it was never released in the documentary. What are their damages? Maybe it was defamatory. If you can get over the petitioning activity problem, which I don't think you can. But where are the damages? If the only people that heard this statement are this documentarian and her small crew, how were you damaged by that? Because the only people publishing them to the public are you. Thank you. The Afro Man effect is in full swing because you're telling us everything and now everyone's paying attention.
You're welcome.
May be on the hook for additional damages, but the defamation that she articulates to Ms. Murr is not enlisting public participation in anything. It is a private statement to Ms. Murr and her small production staff. And as you point out, I think, or Rob pointed out, the idea that there was a plausible nexus between that statement and something that was under review by a judicial body is so far-fetched as to be totally unreasonable.
Really?
That statement wasn't going to...
So far-fetched? Of course it was going to. She wanted them to publish that. She wanted that to air in the documentary. She wanted the world to know that she thinks that Brian Higgins and Colin Albert beat John John was pulverized by them. Her taillight was cracked. She's the one who got arrested and tried twice. This is right before the hung jury. She wanted it to be published because she wanted the world to know that she was innocent. This is so beyond.
Reach any judicial body. By the way, Karen Reed, if she wanted to reach a judicial body, had every opportunity to do that. Instead, she's talking to a documentarian in private and accusing all of my plaintiffs of murder.
So you don't like it when she does it in public, and you don't like it when she does it in private, and you wouldn't like it if she went to the FBI and she couldn't go to the police because they prosecuted her instead of the right people. So you can't use it as a shield and a sword. You can't say, okay, she publicly said all this and she conspired with Aidan Kearney to call us murderers, and he has a large following and a big blog. Make him stop blogging about us, and then say in a little private conversation, it's also defamatory, but where are the damages for that? It's laughable, says Lizzie, and yeah.
Period. There is no nexus to any judicial proceeding. And this does get to the post-verdict statements that we allege she made and that Mr. Kearney has made up until last month. I can touch on that now because the issue of having to analyze whether there's a plausible nexus is one that's going to apply equally to those statements. And what Ms. Reed has argued is that her statements in, I believe, 2026 to the Rotten Mango podcast, in which she again defames our client post-verdict. Well, she says, she argues, that has a plausible nexus to the O'Keefe family's civil case against me, and that by accusing these innocent people of murder, perhaps I can convince the O'Keefe family to drop their case against me. Now, the O'Keefe family isn't a governmental body. They're a private litigant. That's not petitioning activity. And Mr. Kearney equally has a lame excuse for his post-verdict statements, where he...
A lame excuse? I'm sorry, he has a lame excuse. See, this is like, it's not professional. You don't do that. It's just not professional. A lame excuse.
He says, well, there's the statute of limitations for murder still exists. I can spout accusations of murder into the void, and there's some plausible, some governmental entity will pick that up and then prosecute these innocent people for murder. That is simply not plausible.
Really?
It's not reasonable. It's an after-the-fact justification.
You know what's so funny about that is that Adam Deitch is running for DA of Norfolk County. He sold his house and moved to Norfolk County specifically to run for district attorney because he was involved in the federal investigation into the murder of John O'Keefe. And he feels so strongly that he's going to reopen the case if he's elected. So perhaps it just did make a difference, sir. And Rotten Mango, you didn't sue Rotten Mango though, right?
That has no support in any of the case law. Go ahead.
Attorney Seligson, do you want to respond?
Your Honor, the statements are still in connection with the judicial proceeding.
Okay. Attorney Pyle, I guess the characterization really excuse my warrant some response.
Thank you, Your Honor. And
I don't know what is going on with this feed, but he's like, Attorney Pyle, I think the characterization, maybe you want to, respond to that because you're the pro. You're the guy.
I'll note that the argument that was just made, that post-verdict statements can't be petitioning, was not connected to any element of the definition of petitioning in the Anti-Slapp statute. So I'll read one. Any statement reasonably likely would encourage consideration or review of an issue by an executive body. The Norfolk DA's office still exists. Karen Reed has been found not guilty. If Karen Reed's not guilty, somebody else is guilty. Aidan Kearney fervently believes that the plaintiffs are guilty. It is still possible for them to be charged. In fact, one of the allegedly defamatory statements that they identify in this case is a TV interview that he did, not one of his YouTube videos, but a stand-up TV interview right after the verdict. And Aidan Kearney said, I would hope now that Karen Reed has been found not guilty, we can all unite and demand that the Alberts and the McCabes be charged with the killing of John O'Keefe because they're the ones who did it. That is a demand on the government to bring charges. It is a statement also that is reasonably likely to bring about further public participation to demand that charges now be brought against the real killers. That is petitioning.
Attorney Seligson, I didn't give you the chance to argue your motions. What would you like to add?
Attorney Seligson, I didn't give you a chance to argue your motion, so what would you like to add?
Your Honor, what I'd like to add is, without regurgitating what we've already said about stage one of the Bristol asphalt framework, the sole crux of the complaint, the amended complaint, this lawsuit against my client is solely based on statements that are petitioning activity protected and immunizing her under the Anti-Slapp statute. The second prong of the framework requires the burden to shift back to the plaintiffs to show that the statements are devoid of any factual support or any legal basis. We have put forward enough evidence. You referenced the affidavit and the transcripts attached to my declaration affidavit. That's in there, and they cited to in our brief. But the facts that established at stage 2 of the framework, most importantly, my client was acquitted of the prosecution's charge that she was responsible for John McCabe. The case of Faber versus Walton, the holding was judgment in favor of a party to litigation is conclusive evidence that petitioning activity was not devoid of any reasonable factual or arguable basis in law. She submitted an affidavit that she did not strike Mr. O'Keefe with her vehicle.
What's the nexus between the finding of the Norfolk Superior Court in a criminal case against
What's the nexus between the finding of the Norfolk Superior Court in a criminal case
one defendant to claims against these plaintiffs?
Because
to claims against these plaintiffs?
her petitioning speech has to be supported by facts. They have to disprove that there are facts to support her petitioning speech. So that fact is highly relevant. She didn't strike Mr. O'Keefe with her vehicle. The chief medical examiner, Dr. Irini Scoribello, testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, that they were consistent with a physical altercation. Mr. O'Keefe did not show signs of a physical altercation before Ms. Reed dropped him off at 34 Fairview Road in Canton. They did not have an altercation at the Albert's house. He suffered a wound on the back of his head, which was consistent with falling on a ridge surface. Present in the basement garage at 34 Fairview Road, Mr. O'Keefe had wounds on his arm, consistent with a dog bite. There was a German Shepherd in the home with a history of aggression. That's also testimony from the trial. Mr. O'Keefe's phone was at some point inside the Albert's home. That's testimony from Mr. Ian Whiffen. Ms. McCabe used her phone at 2:27 a.m. on January 29th to type in how long it takes for a person to die in the cold. That's the testimony of Richard Green from the trial. In the early morning hours of January 29th, 2022, Mr. O'Keefe's body was not present where it was later found. That's the testimony of the plow driver, Lucky Lawford. And then there's a testimony from Dr. La Posada, the former chief medical examiner for Rhode Island and a professor at Brown University, who opined that Mr. O'Keefe died from a massive skull fracture that was inconsistent with a vehicle strike. Those are the facts that the plaintiffs now have to prove are somehow devoid of proof. So the statements are petitioning. They are covered by the Anti-Slapp statute. The amended complaint rests solely on those statements. And the support for her petitioning activity is factually supported by what I've just read and what I've submitted to the court attached to my affidavit. For those reasons, Your Honor, for those reasons, I ask that the court dismiss the lawsuit against my client and award her attorney's fees as is provided under the Anti-Slapp statute.
Thank you, Attorney Stubbs. Anybody want to respond to Ms. Reed's arguments?
Just briefly, Your Honor. And before I do, I did just want to point out, in response to the court's question earlier to Attorney Pyle about whether posting to social media is, by its very nature, petitioning activity. We cite the Sheehan case in our brief, which stands for exactly the opposite. I hesitate, Your Honor, to even engage with what I just heard, because I think it's prejudicial to my clients to even entertain what I believe is just nonsensical recitation of evidence that doesn't implicate any of them in crime.
Nonsensical. He hesitates to even respond because it's so nonsensical. Okay.
That has been shown to be discredited. And I'll start by pointing out that he doesn't mention Colin Albert once. Doesn't mention him once.
That's okay, because he mentions him in his papers quite a bit. Brian Albert and Colin Albert pulverized. John was pulverized. They beat him up. John was pulverized and my taillight was cracked. Okay. Understand that you can't argue every single thing that's in your papers during these hearings, but the papers we've seen the papers. They're very long. They're like, well, they had a limit, but I think they both moved to enlarge and they're like 30 pages plus exhibits. So, it's in the papers about Colin Albert. So, I mean, if you're pandering to the media, by all means, go right ahead. But, it's in the papers. We know because we read them.
And the reason he doesn't mention him once is because he knows that the undisputed evidence, as we present in our brief, is that Colin Albert wasn't even there when Mr. O'Keefe arrived. And because
Colin Albert wasn't even there when Mr. O'Keefe arrived. Well, here's the thing about that, sir. I don't know if you know, but Allie McCabe's Life 360 data was recently brought up somewhere. And what had happened was, it turns out that Allie McCabe's Life 360 data shows that she did not go anywhere near to or fro 34 Fairview on January 29th, 2022 at all, ever. Neither did she ever go to Colin Albert's house. So here's the thing that day. So here's the thing. It's refuted. It. Maybe you don't know it, but if you don't know it, you should. And so it's a question of fact, sir. And why is Colin hiding in the Army, says Donna. So there's new evidence about that, and I'm surprised he's not up to snuff on that or up to speed.
he knows that the other evidence that they suggested implicated Colin Albert in some sort of altercation, that is that at some point he had scab knuckles, that they were in possession of photographs that show him before that and after Mr. O'Keefe's death with completely uninjured knuckles.
Yeah, because we can trust the metadata. Technically, Mr. Jackson, technically, it's not perjury, technically. Thanks, Kylie.
So I only raise that to show just how frivolous these arguments are with respect to Ms. McCabe. Attorney Seligson just said again here in open court that Ms. McCabe Googled how long to dine called at 2:27 a.m.
Right.
That is not true. That was established to be definitively not true in the second trial. Ms. Reed did not allege it in the second trial. She didn't even call the discredited expert who Mr. Seligson
discredited expert. Yeah. Because Celebrite changed their software afterwards. Because isn't it still 227 in Axiom and Magnet software? Tell me the other softwares where it's 227 lives in other software other than Celebrite. But Ian Whiffin's going to come in and testify for Lindsay Clancy in opposition to Lindsay Clancy, and I can't wait. And unless he obliterated Whiffin on cross, sir. But keep going with your bad self.
Contrary, Celebrite officials who managed that software testified without contest that server showed up at 2:27 a.m. because a previously opened window was used to conduct the search after 6 in the morning. And that was a feature of the software and no evidence at all that the searches happened at that time. And obviously it's absurd to even suggest it because then there are two searches, I believe it's 623 and 624, that are miskeyed in exactly the same way as the prior.
No. Let me school you, okay? Haas long to die in cold was Googled at 2:27 a.m. And then at 6:23 a.m. it was how long TIDIENCIKD or something like that, right? And then at 6:24 it had to match the 227 search. So it was then typed in Hoslong to die in cold. And then the funny thing is that the 227 search was deleted from Jennifer McCabe's phone. So, you know, it's going to be battle of the experts in the civil case too. But I mean, listen, your clients are probably paying you a lot of money. And so get up there and scream all the things that we know can be refuted. Because as you know, civil discovery is very broad.
It's just nonsense. And I think that the important thing is, as you point out, the fact that a jury was not able to reach a verdict as to this, the fact that a jury concluded that there was not sufficient evidence beyond a reasonable doubt to convict Ms. Reed of these crimes is not affirmative evidence that anybody else committed them, much less witnesses who have never been targets, never been subjects, testified in open court multiple times. It's just offensive to hear that type of argument here. Now, I don't think you're ever going to get to that stage of the analysis.
It's offensive. It's offensive. Well, you better buckle up, because that is exactly what your whole entire trial is going to be about. It's offensive. Even the feds agreed with 227. And Emily C says even the video feed is having trouble repeating these lies.
Because I think, as we've shown, none of the allegations we've made against Mr. or Mr. Kearney in petitioning activity have you shown it. I'm sorry?
None of them?
None of them. I mean,
He says none of them. None of these statements are petitioning activity. And the judge says none of them, which makes me think the judge is thinking maybe some of them are, some of them aren't.
I think there is, as Mr. Pyle has suggested, Mr. Kearney separately, now I'm not acknowledging that this was petitioning or not, but Mr. Kearney has engaged in criticism of the Norfolk DA's office, and police department, and the police. None of that is at issue in this case. And yes, Your Honor, none of his accusations of our clients that they committed murder was petitioning activity. Not a single one. Not a single one. And there is no case to suggest that that sort of accusation against a private citizen, untethered to any effort to report to the government, is petitioning. None. And so the question I think that this case presents is whether or not this court is going to radically expand anti-Slapp protections to include what historically has been considered defamation per se, and shut the courthouse doors to people like my clients who come here seeking and invoking the court's protection to press their claims, or whether they will have no civil recourse, not just them, but any resident of Massachusetts who is falsely accused of a crime by another citizen untethered to any petitioning activity, whether they will have civil remedies or not. And to me, the case law that we cite in our brief makes it clear that the narrow purpose for which the anti-Slapp statute was enacted certainly does not extend to what historically has always been understood to be defamation per se, the worst type of defamation, the accusation of one citizen of another, a false accusation that they've committed a heinous crime of murder when that has not been tethered to any report, any petition, anything.
The FBI was already investigating. And who are they going to report to? They're trying to get the public involved. Or Aidan, trying to get the public involved. So when the defamation is tied to petitioning activity, you don't even get to. You can still dismiss defamation claims if they are petitioning activity, which I think is the next thing that Pyle's going to argue.
With respect to
It's almost over.
Thank you.
Attorney Seligson, anything else?
No, Your Honor, I stand by my
Attorney Pyle.
Yes, Your Honor. The suggestion is repeatedly made that accusations of murder against private people are not protected by the Anti-Slapp law. That's not the law. And Mr. Mattei just said that those statements can't be protected by the quote, very narrow purposes for which the Anti-Slapp statute is enacted. The Supreme Judicial Court in the Duracraft case noted that the language of the Anti-Slapp statute is in fact very broad. It broadly protects petitioning activity, yes, even when it results in the dismissal of an otherwise meritorious defamation claim. It has long been the law, at least since McDonald versus Payton, which we've cited in our brief, that anti-Slapp applies to defamation claims. It doesn't matter if it's defamation per se, which is one of the old common law characterizations of defamation, the commission of a crime loathsome disease, or whether it's defamation per quod. It applies to defamation cases. These plaintiffs' defamation claim is based solely on Mr. Kearney's accusations that they committed murder, and those accusations were inextricably bound up in his protests against the prosecution of Karen Reed and the failure of the government to investigate the plaintiffs. The notion that there's no reasonable factual support for Mr. Kearney's petitioning activity is laughable, given the extensive evidence that you've heard about at the trial and that our brief explains in great detail. Mr. Mattei didn't say anything about the Ford Edge that Lucky Law Friends saw parked in front of 34 Fairview.
Bang, bang. Bang, bang. He didn't say anything about the Ford Edge. Bang, bang. Laughable. See, he didn't call him lame. He said it's laughable.
There's no explanation for that. The notion that he cannot make these statements, comment on a pending criminal case in order to get people involved in this matter is simply not accurate. The Anti-Slapp statute provides very broad protection for petitioning activity. And it doesn't require that anybody report anything to the government. It extends to statements that are made that are intended indirectly or directly to reach the government. That concludes my argument on the anti-Slapp motion. I did want to raise one other housekeeping matter with Your Honor in order so that the record can be clear. Back at the Rule 16 conference, Your Honor asked the plaintiffs to file a thumb drive containing all of the allegedly defamatory videos. You have received such a thumb drive?
The judge says, we got it. But remember, the thumb drive was supposed to be all of the hyperlinks and all of the video attached to the complaint, not to their opposition to their motion, to the complaint. And he's like, you got it? Because we didn't get it. Yeah, there was a wild change in volume, so I'll unboost it on my end. Hold on. They finally figured it out at the very, very, very end. Shout out to Towel News Network and Grant Smith Ellis.
Oh, the defamatory videos. We got it. You have received such a thumb drive? Oh, I didn't know that because I didn't receive a copy. I'm glad that that thumb drive is now in the record. I know there was a thumb drive attached to the anti-Slapp motion that may have contained a few of the videos. I'm not sure if they
right? I don't think we noted that we received it, no.
And then the judge says, yeah, we have. And then he asks the clerk, did we receive it? And she says, no, I don't see that we've received it, Judge.
All right. They'd sent it in. They sent a thumb drive in with the links and all that.
Yeah, not in the complaint.
Containing every allegedly defamatory video in the case? Okay. Thank you, Your Honor. That satisfies me on the issue. I would request a copy.
Happy to give you a copy, Your Honor, very briefly in response.
Do you think they filed that thumb drive with the complaint? All of the footnotes in that amended complaint, do you think they filed that? Or do you think that it was just for his opposition to the motion? Because the judge seems pretty damn sure he saw the thumb drive with everything. And it doesn't seem like it to me because the clerk doesn't see it.
The Duracraft case cited by counsel.
It was cited by everyone.
Which
I cited it too, so.
Which I relied on in saying that the purposes of the anti-Slapp statute are narrow, reads as follows. Section 59H is, quote, strong medicine and used only in a limited context, requiring, quote, necessarily narrow and strict construction. That's what I was relying on when I made that observation to the court. And the last thing I'll say is, it is of course true that the anti-Slapp statute.
Ooh, do I spy Silver Fox Tim Bradle in the corner? Is that Tim Bradle? I think we've seen that suit before. Was anybody boots on the ground today in this courtroom? Okay. All right. It's his summer suit.
Applies to defamation. The point that we made, and I think the point that counsel doesn't even dispute, is that where the defamation involves accusation of a private citizen of murder, and that accusation is not made to a law enforcement agency or the government, that it has never been given petitioning protection.
Okay. Thank you all for your arguments. The matter will be taken under advisement. Can I speak with all counsel at the side of the bench, please?
Okay, and then they go to sidebar, and that is that. And there's the a little shot of the gallery. Not really sure who's there because I can't see, but I spy Tim Bradle, and he doesn't use a backpack. And I bet that Jeffrey Pyle doesn't use a backpack either because he was even wearing cufflinks. Okay, he had cufflinks on. He's a man of cufflinks. I do love a good French cuff shirt. I think cufflinks are important, as our collar states, for those who don't know. Thoughts, questions, comments, concerns. I was going to take a quick look at the allegations about Terry Murr in the amended complaint, but I think we kind of covered most of them. And I also want you to see Grant Smith Ellis's video of the Haas plaintiffs walking into federal court. Do you want to see that? Do you want to see that? Yeah, hang on a second. Mark Betterow would never carry a backpack. He would never in a million years. Death before backpack. All right, let's take a look. Towel News Network on the case. He's outside federal court. Go follow him on all the things. I'm so happy that he had such a big live audience this morning. I'm really happy about that you guys went over there and that you supported him. And I was having my propofol nap. And please hit the like button. Here he is outside federal court. Haas defendants, because remember, they're the defendants in the federal case. This is the case of Karen Reed versus everybody. She originally brought it in Bristol County. Then they removed it to federal court. Let us see. He had on my hat today. I know. Here we go. Here they are. Brian Albert. I guess that's Jennifer McCabe with the black blazer. Hold on. Maybe we could zoom in a little scoochy bit. Or not. Let's see. A lot of cameras there. Brian Albert. Chris Albert. Who dat? Jennifer McCabe and Matt McCabe. All right. Oh, please. That's going to loop. There's more. Okay, he's got that. He said they had no comment. I guess he tried to talk to them. And then Yuri Buchanan walking in. If you guys didn't see the video of Yuri Buchanan's karaoke on the cruise that he was recently on, it is quite something to see. It is something to see. He seems to love karaoke. And he was singing, I'm proud to be an American, or at least I know I'm free. But remember during the trial, he said English is his third language. And he needed a dictionary so that they could define the word theory for him. Here he is, because he is also a defendant in this case. That's why he's there. This is the case, the Karen Reed versus everybody. So Yuri Buchanan is a defendant. Michael Proctor is a defendant. Let's see. Here it is. Bye, clip.
Yuri, you want to say anything? Best of luck to Ukraine.
Yuri,
you want to say anything? Best of luck to Ukraine.
Best to you, what? He said, Tal said something to him. Best to you. It sounded like brain. I don't know. All right. And then there's more, but wait, there's more. Here is Yuri Buchanan's lawyer arriving for today's 3 p.m. Karen Reed versus Ham. And what is that? Higgins, Albert McCabe. Federal hearing. I'm never going to use Ham. I'm never going to use it. I say Haas defendants and Haas plaintiffs. Yuri had no comment. And he said, best of luck to the Ukraine. He said, even though Yuri has me blocked on X, I still wish the best of luck to Ukraine. Yuri didn't respond to that either. But apparently his attorney, Yuri's attorney, did. So hold on. Best of luck to the Ukraine. He's really funny. Give him a watch. And in fact, I would suggest after you're done here, if you didn't already watch him this morning, watch his analysis after the hearing ends, because he had some funny stuff to say. And he's like all about smoking like big doobies on the air. Like he's funny. He doesn't care. He has no F's left to give.
Before you head in.
Okay, let's do it.
One time we were having an argument with the editor of the Globe, and the reporter said, well, then he said he wouldn't talk. And he goes, he never says he won't talk. Yes?
Tell us what you think of this lawsuit.
I'm absolutely confident that Sergeant Koenig is going to be vindicated. He did everything right, and the evidence demonstrated what it demonstrated.
Do you think this?
He says Yuri Buchanan did everything right, and the evidence demonstrated what it demonstrated. The problem is they didn't collect any. They didn't, you know, they should have considered Higgins a suspect, and they never did. Even though he was trying to bang his friend's girl, you know, who happens to be the defendant. No big what.
Lawsuit has any merit for any of the defendants? I mean, it's there's a lot of people named.
The lawsuit alleges that she was framed. She wasn't framed.
Expand on that.
She wasn't framed. Okay.
How do you plan to defend it?
Simply, the conspiracy theory pushed by her side is preposterous. You would have to believe that John O'Keefe's friends knocked him out, injured him severely, and instead of treating him, decided to murder him.
Well, here's the thing. They weren't his friend. They weren't his friends. They were not his friends. See? They weren't. Thank you, Kyle Sharkey. I don't have time to read motions right now, but I will take a look for your email and certainly take a look at them. If you weren't here earlier, I did have a little propofol nap this morning during my colonoscopy. It was just routine. Come back in 3 years, all good. But I'm a little tired. So we'll have something to cover tomorrow. How about that? You would have to believe what? That first of all, they were not friends with John O'Keefe, right? They were friends with each other and family. They were all family and friends.
Decided to murder him. Not conspiracy theory.
You don't have to determine that they decided to murder him. Something happened. And rather than, call 911, because maybe the guy died right away, because they did say, based on the injuries to the back of his head, he would have died right away, right? Or very soon thereafter. So if something happened that was like an accident and he died right away, would it be easier to call 911 and explain how this man died on your property and risk, a lawsuit and all kinds of other things? Because maybe your dog got involved and maybe you're going to, I don't know, lose your house, your pension, that kind of stuff. Or do drunk people make stupid decisions and in the heat of the moment, maybe decided to just try and frame Lucky, right? Because they probably knew that Lucky already hit somebody with his plow a couple of years before. They were like, oh, everyone will believe that Lucky hit him with the plow because we know that Lucky plows the street. They've known Lucky since they were kids. That's why he didn't plow when the Ford Edge was outside, because he didn't want to get the Alberts in trouble. Okay?
Pushed by her side is preposterous. You would have to believe that John O'Keefe's friends knocked him out, injured him severely, and instead of treating him, decided to murder him. And to deflect the tension from themselves, they put the body on their front lawn. Let me tell you, when you kill somebody, put the body on my front, not yours.
Doesn't make sense.
Yeah, about that. Well, since they were all curtain twitching, and that's the last place they say they saw Karen's car, especially the curtain twitchers of Matt McCabe and Jen McCabe, they say they saw her car right where his body was found at 12:45, which is so funny because Karen connected to the Wi-Fi at One Meadows at 12, what was it, 12:36, 12:34, and they say they saw her car outside at 12:45. So, yeah, there's that. So they thought maybe that would be good, because if his body was found somewhere else, how could they ever pin it on another person? Karen dropped him off there. It was their dear friend, but they tell him the guy never went in the house. There's a man passed out in the snow. There's the guy unresponsive, send somebody. That was their dear friend. Did you watch the movie, sir? Did you watch both seasons?
Sense to you.
Of course not. Never made sense.
Hey, what did he say?
And to deflect the tension from themselves, they put the body on their front lawn. Let me tell you, when you kill somebody, put the body on my front, not yours.
Doesn't make sense to you.
Is that how you would defend a murderer? They would put the body on your front lawn. Remember what Higgins said at Ken Berkowitz's retirement party. Higgins gave a speech and he said, Ken Berkowitz is the kind of guy, if you need help burying a body, that's the guy you call. Now that video has been scrubbed from the internet. You will no longer find it. It was Ken Berkowitz's retirement party. But that's what he said, remember? Drunk people make stupid decisions. I think we can all agree on that, right?
Of course not. Never made some.
Can you put your name on tape for us?
Leonard Keston, K-E-S-T-N. Firm name is Brody Ardoon Brookins and P. Keston.
Leonard
A
Keston.
lot of
I
partners.
represent McCabe.
Thank you.
Leonard Keston. He's probably, I would say, a union lawyer, right? Because here he was sued in his professional capacity. The union hasn't abandoned him yet. And so I imagine that he's the union lawyer. The federal hearing would begin at 3 p.m. And so I think he was going into, so that was when his attorney was walking in. So I imagine that it has not ended yet, but I suggest that if you do engage on the cesspool of Twitter, go over there and follow Grant Smith Ellis. Maybe he's also going to be updating his YouTube postings, but go on over there, give him a like and a sub and all the things, if you would. Redemption. I'm here for the redemption tour of 2026. Sarah, thank you for your 5, but that creator that you're mentioning in your super chat has said some not very nice things about me, so I'm not going to put it on the screen. Emily, thank you for 10, says I'm from Connecticut and that Sandy Hook trial was awful, but to compare Turtleboy to Alex Jones is crazy work. 2 completely different things in my opinion. Free Turtle. Donkey's Noggin, why is it that when these lawyers working for the antis don't have a case, they throw out low blows? I mean, you know why? Because as Socrates once said, somebody said to me the other day, that's not what Socrates said. And I say that's what the meme says. So I don't know if Socrates says it or not, but I'm going to attribute it to Socrates. And I'm going to go over here in the corner and just remind you that when the debate is lost, slander becomes the tool of the loser. And it does say Socrates on there, but that's what happens. When the debate is lost, slander becomes the tool of the loser. So that. Thanks for your 5. Babes, Mom, thank you for your 5. Tammy, hey, Mel, I finally got my hat. Thank you so much. It was awesome because it came today on my birthday. Happy birthday, Tammy Tebow. Sorry it takes a while, but, you know, it's print to order, so I have nothing to do with it. It's not like Amazon where it comes to you in 48 hours, but I'm glad you like it. We did a hat giveaway one day, and a couple people won hats. Yellow Libero says he reached the government the second Marcy made his hostage speech. Yes, that's a great argument. That's a great argument. Michael Marcy gave a hostage speech in August of 2023 after Aidan Kearney started reporting on this case when Jennifer McCabe said, can't you make him stop blogging about me? Where he said all kinds of things, you know, because we've watched that many, 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 many times. That's a great point. Robin, thank you for your super chat. It's Sunny in Naples says Aidan did reach the government. That's why Marcy did the hostage video. Duh, Maddie. Yep. Nobody brought that up. I'm surprised. Surprised nobody brought that up. I don't think anybody saw Higgins. I didn't see any video of Higgins. This attorney's on fire. Mic drop says jump and shout. Thanks for your 5. Cindy says, I love this attorney as well. Amazing. Thanks. $22.70. Oh, for 227. I feel you. Thank you, Cindy. Victor Mann says Grant is going to live tweet the federal hearing. Well, he cannot tweet from inside the courtroom. He just can't. They will ban him. They will throw him out. That's why we just watched his videos from outside the courthouse. But I'm sure he will go live afterwards. And so check it out. Deborah says, learning a lot from you and all the cupcakes. Love you, Melanie. Thank you, Deborah. For you 20. Donkey Noggin. Thank you for telling everyone to hit the like button. Chi-Chi's here. Cherry picking without a cherry tree is fruitless. Oh, well done. Well done. Cupcakes petitioning for activity. Well done. Says mainstream media never covered the story, so Aidan had to get the word out as a journalist. Right. Donkey's Noggin says, I watched both trials and I've seen the evidence. And in my opinion, the people in the House, along with government officials, covered this up. Kelly says, I still haven't watched a full Turtleboy episode. The Haas defendants still look guilty and weren't investigated to prove otherwise. Silver Fox says, I don't understand that the Haas group is still saying she killed John, yet Turtleboy and Karen can't say they did it. Did we not clear her already? She was cleared, and they keep saying she's a murderer. So I don't know. Will she bring a defamation lawsuit? I don't know. I think she's got bigger fish to fry right now. But thank you for your super chat, Sweet Pea. And Donkey's Noggin says Turtleboy was right. Wildflower says it's my picture. Turtleboy is right. Thanks for being here for 23 months. You guys are very, very, very loyal. Very loyal. If you're not subscribed, hit the subscribe button. What are you waiting for? It's free. And Foxy Wolf says this, which I find interesting. You watch. The judge will dismiss Aidan's case, but not Karen Reed's case, because Foxy Wolf thinks that the judge is out for Karen Reed. And I was thinking, not exactly the same thing, but I was thinking, wouldn't it be so ironic if Aidan's case is dismissed because of all of the clear petitioning activity, and then Karen's case is not because her attorneys failed to address the things that she said in that very small closed room to Terry Moorer? Wouldn't that be crazy? Charles, thank you so much for tuning in from South Africa and for your generous super chat. Says, I watched the Jones case and attorney Mattei won a directed verdict. He said Jones withheld discovery. He referred to YouTube analytics that Jones couldn't get because he had been banned for years. Mattei said he had old copies that Jones had on file. Yeah, it was a default judgment is what it was. And you remember Judge Gildea threatening a default judgment recently with regard to the Proctor thing and the private medical information that he said the spirit of his order was violated because somebody told Aidan Kearney that Michael Proctor was in a mental health inpatient place in Florida. And then he agreed that the tweet was earlier than the filing. And then he considered another tweet that he was having a panic attack. That was a public hallway picture. The whole thing is crazy. And so I'm glad that we can do it together because misery loves company, I guess. Anne-Marie says, ugh, I'm late. Dang, getting in the way. Sorry if you're working. I try and keep you company during your work days. Victor Man says, if Turtleboy slap is denied, can he get an interlocutory appeal? There are very slim circumstances in which interlocutory appeals can be filed in Massachusetts, and I'm not 100% familiar with the law, and so I do not want to give you the wrong information, but I will find out. My gut is what's going to happen here is like a partial granting and a partial denying, similar to the wrongful death case. Some counts were thrown out and some remained. Thanks for your super chats. Kraft asks if the judge could be impartial, allowing him to oversee all things Karen Reed and Turtleboy would have made sense, but he's not. He needs to be recused, in my opinion. Thanks, Mel. Thanks for tuning in from across the pond. May the force be with you. Gifted 10 memberships. Thank you so much. You were so very kind and generous. And to the 10 who were randomly gifted, welcome. I think you're going to like it here. Thank you so much. Cindy, thank you so much. I'm feeling great. Thank you for your comment and for your 10. Charlie said, and the courts wonder why they are despised by 99.9% of the public. Listen, we've seen a lot of really good judges, so I can't say that everything we watch is bad. I just tend to focus on the things that I feel passionately about, and I feel passionately about people who are being unjustly persecuted. And so those are the things that I watch on my channel. But there are very good judges out there, so we cannot, just like there's good lawyers, good cops, good doctors, not all are bad. See you, Buff's mom became a member. Welcome, Sco Buffs. Oh, you see what I have on today? It's vintage. Remember this? 122nd U.S. Golf Open at the Country Club in Brookline. For those of you who may remember, back in 2022, the U.S. Open Golf was played at the Country Club. The Country Club. It's just called the Country Club because everyone knows about it. It's in Brookline, Massachusetts. And the winner was, let's see, Matt Fitzpatrick, an English golfer. Where's he been since then? I don't know. But it matches my green Hawaii. University of Hawaii, represent. We have a rainbow warrior. Okay, moving on. Overruled. Satan says, I thought the first issue of Turtleboy was based on information from a police officer. You mean that's how he got interested in the case? I think so. I think it didn't have to do with Karen at all. I think you're right. Donkey's noggin. So we will never see justice for John O'Keefe in Massachusetts. So in my opinion, the thin blue line is strong except for a select few. 3-5. Next motion is a motion to recuse, says Victor Man. We're all entitled to justice, says Cammie. Virtual juror says anagrams. Agile judged. Aided juggle. Idea juggled. Dead I juggle. And DJ Gage lied. Well, if you just do Gildea in your anagram, you get Gilead. And that is why sometimes we put up the Handmaid's Tale rubber duck, because it feels like we're in Gilead. This is very Handmaid's Tale-esque. And the absurdity of the rubber duck investigation by the Canton PD, they did a 36-page police report. Go back and watch my stream on it, because a guy named Richard Schiffer put some little rubber ducks around town with little stickers on the bottom that said Colin did it and IYKYK. They did trash polls. They downloaded his text stream data, and he littered some fake Monopoly money around town that said justice for John O'Keefe. Better investigation into the rubber ducks than into the death of a murder of a Boston police officer. Thank you, Donkey's Noggin. Theodose. Sweet Southern Harmony says, aren't judges barred from doing outside research? They're not supposed to do outside research. Or am I confused about the rules of judicial ethics? They're not supposed to be doing outside research. Donkey's Noggin. Jen McCabe never said in a federal hearing that Karen said, I hit him. But in front of Kearney, Jen said I hit him 3 times, right? Jenny, that's why I called Jenny 3 times. Remember, well, I forget, was it Goodfellas? It was Jimmy 2 times. Show me the papers. I got to get the papers. That's why I say papers. I think it was Goodfellas. Jezebel says they're terrified of rotten mango. Her team will obliterate them. Wait, please do try. I want to see that. 3-5. Donkey's Noggin says, at this point, I want to go to trial to shut these lies down. Sorry, I'm just pissed off because I fought in Iraq for the Constitution. Thank you for your service. Thank you, Donkey's Noggin, for your service. Do you feel safer knowing that Colin Albert is now protecting us in the United States Army? Just wondering. Oh, please. Thanks for all your super chats today. Shirtlocker says we need a judge insider who understands his moods or what desserts he likes. Thank you. Genosaurus Rex says Mattei's offensive. Bedro says, so they're going to be saying John O'Keefe killed himself. This is just madness. Now they're going to say Karen did it. She just wasn't convicted for it. And remember, just because someone's acquitted in a criminal trial doesn't mean they can't be found liable in civil court. Think OJ. Right? Thank you, Kim, for your super chat. Kyle says they're all special purpose public figures. They didn't even get to that analysis yet. Thanks, Kyle. That would be in a regular defamation case. I don't think anti-Slapp matters for that analysis, but thank you for that. Johnny says unsolved murder is whose job? Government's, last time I checked. I could be wrong on that, Kyle, but they haven't touched on it, so that's what I'm thinking. Barry says, methinks the Mattei doth protest too much. That could be a 10. At Fort Dread says, Judge G is showing his bias and disdain for Karen Reed and Turtleboy by the questions he asks them versus Mattei. This is BS, but we knew not one Commonwealth judge would grant this, but you bet your ass a jury of their peers will. Will they ever be able to find an impartial jury? Thank you for your 10. Tons of fun says Karen's speech at the acquittal should be played here. Yeah, at the trial, for sure. Thanks for being here for 15 months. At Fort Dread says, excuse me, sir, what the F would the government do? They turned several blind eyes only to pin it on the girl. Right. How are they going to go to the government with their grievances? I mean, the government's not going to help them. The FBI tried. The FBI released 3,071 pages of exculpatory material to both sides before trial number 1 and told both sides in good conscience, I cannot allow this case to go to trial. So Josh Levy, the acting U.S. attorney for Massachusetts, told Adam Lally and Karen Reed's team, thinking any ethical prosecutor would at that point just dismiss the charges because they were baseless. And yet, not only did they continue to prosecute her, they prosecuted her twice. And so something much bigger, in my opinion, is at play here. And we're here for every minute of it. Thank you, Lainey. Says for you and Tom Kokonowski, Pyle graduated from Trinity. Oh, that's interesting. I wonder what year he graduated in. That's so interesting. Susanna says, you bless me every day. Thanks so much for all you do. Thank you for your Venmo. Susanna. Oh, Susanna. Kyle said, chat may be too fast. Did not seen. There were a couple of motions filed in O'Keefe versus Reed and McCabe versus Kearney Reed. Opposition to judge's proposed order regarding Proctor. Excellent. That will give us something to talk about tomorrow. Johnny said, Seligson seemed a bit lost and needs to be a lot faster on his feet about Karen Reed in front of this judge. Pyle seemed way more on top of his argument, in my opinion. I thought he seemed a little shaken. I thought he was a little shooketh as well. I did also make that observation. Tell me what you guys think. Did you guys think that Seligson was a little off his game? Because the judge came charging at him, and it can throw you off. And also, this is Pyle's wheelhouse. This is what he does. He makes these arguments every single day. It's his specialty. And so he did feel a little off his game. But remember, they got to be in federal court. I don't know who's arguing for Karen in federal court this afternoon. I don't know if Alan Jackson's going to be arguing in federal court, but we watched him yesterday argue in the phone hearing, and it was glorious. And we realized how much we absolutely miss him. Thank you to someone who bought me 3 matcha lattes that says thank you from Texas. It doesn't have your name in there, but thank you so much for your matcha lattes. I'm going to need them all because I was up really, really, really early this morning. Thank you, Johnny. Craftastical says, tonight we are living a very historic moment in my town. A physical border separating Spain and Gibraltar has existed for 313 years, and at midnight it will come down. Wow, that's exciting. Great things can happen when people agree and get along. I love that. So it's soon now, right? I mean, are you 5 hours ahead or 6? It's 4:30 p.m. on the East Coast right now. When I was recently in London, they were 5 hours ahead. And so it depends, I guess, on your time zone. Thank you so much. Thank you, Mrs. Bouquet, for your super sticker. Shout out to Harrison if he's here with you. Minnesota Mama, I think that is 405. Anytime the McAlberts, their lawyers, or any anti-Karen Reed talk about their facts of the case, all I can hear in my head is the song Gaslighter by the Dixie Chicks. Thank you for your 10. My dog named Bing says, glad you're feeling good after your nap today. It's the best nap ever. Thanks for being here for 27 months. And Music to My Soul says, looking forward to Gildea grilling Tux, I call him Jimbo, Tuxberry and Mattei, about why they submitted the same affidavit for Colin in the defamation case as the wrongful death case with almost the same caption, or maybe not. But yeah, here's the thing, right? They submitted that same affidavit, right? That has nothing to do with the issues at hand. And also, whose attorney was it? I think it was Proctor's attorney, who submitted a court filing with a case that did not even exist. A made-up case. Like he used ChatGPT to write his responsive pleading or whatever pleading it was, or his motion to get Proctor out of a deposition, and he cited a case that was made up. And the judge takes every opportunity he can to spank Karen's lawyers in front of the world. It was Tully's lawyer? It was Tully's lawyer. Thank you. It was Tully's lawyer who made up a case. Clearly using AI, because that's what AI does, because, Westlaw and Lexis is proprietary. You can't get the cases unless you pay for it. And then he quickly filed something apologizing and even admitted that it was a made-up case. Not even a mention. Not even a mention. Thanks, Olivia. Hi, Olivia. So thank you, Music to My Soul, for your 10. It was Tully's. Thank you. Thanks for reminding me. Kay Willis, thank you for gifting 5 memberships. Kay Willis is an amazing realtor south of Boston. If you need to get out or buy, she's your girl. Thanks, Kay. You're so generous. And Ball Mom 2 Owen has been here for 8 months. All right. Thoughts, questions, comments, concerns before we wrap this 2.5-hour stream so I can go take a nap or just go to bed because I was up really early this morning. Lisa says, in addition to Lucky, Craig Casey was found dead on a lawn in Canton in 2018. Yes, I've covered that. In the morning, despite a police search, yes, he was ejected from his vehicle and they didn't even look for him. He was found by a neighbor, as I recall. One more reason this scenario would make sense to someone, right? Dina's here. Thanks for your 20, sweetie. Judge G can't help but to show his distaste for Karen and Aidan's lawyers. Disgusting display of bias. I had to bite my finger to hold myself from yelling out. Were you in court today? Especially when Ham lawyers said 227 never happened. Oh, Dina. Good that you held your tongue. You know, so it's hard. I know. That's why I can't even go. I have to just stay here and yell into my microphone because I fear. I fear that I would burst out as well. Thanks, Melisa. Thank you, Melisa. I ain't got no quit. Neither do you. Neither do you guys. Do you think the judge has it against Karen Reed's lawyers because they're not local? But they are. Damon Seligson is local. His firm is local. It's Alan Jackson that's not local, and I don't know. I don't know where the orders are coming from. I don't know, but I do think we have seen a shift in Judge Gildea's behavior since he had this case in the beginning, and I shudder to think, but I think it's going to happen, that Karen Reed's lawsuit against the town of Canton and the MSP that has been filed in Bristol is going to also be handpicked out of Bristol and handed to Judge Gildea. I think it's going to happen. Bookmark this. Dancing Quinn says, that's what I call dedication. Thank you. Go to sleep. Thank you. Alienated Sharpness said, he seemed receptive to Pyle, but he was also more prepped and prepared. Yeah, and this is what he does for a living. It's what he does. You know, it's his wheelhouse. Keep on trucking. Buckle up, Buttercup. Thanks, Wendy. All right, I think I got everybody. Thank you, Meditating Honey Badger, Meditating Honey Badger, for upgrading to floor seats. Listen, just so you know, if you're international, YouTube is jacking up the prices internationally for memberships. It has nothing to do with me and everything to do with the exchange rates. But if you join now before, I think, August 17th, you'll be grandfathered into the old membership rates. So if you choose to be a member, we would love to have you. Thank you. I'll see you guys very soon, like tomorrow. So make sure you have your notifications set. Make sure you do all the things that YouTube likes to help the algorithm. Like the stream, share the stream, comment respectfully. And we'll see. How much time would they have to decide whether to reassign the Bristol action? I mean, typically, I don't know how long it was in the case of this case, the Barnstable case. I don't know how long it was, but I think it was typically the defendants have 30 days to answer from the service of the complaint, but oftentimes they ask for an extension of time to answer for maybe another 30 days. So typically it's done before the answer comes in, but it really can be done at any time. And I mean, it kind of makes sense to have him handling all of them, but it just makes it look a little more, it gives the appearance of something that we call impropriety. Thank you, Quizzical Girl, for becoming a member. I love you guys. I don't know why the video is freezing. Mine's not freezing. It was Grant. Everyone go give Grant Smith Ellis a like and a sub. And if you can help him out with some lunch money, I'm sure he would appreciate that too. Thank you, Mrs. Jim Marson. Love you. And Debbie, thank you very much for being here. All right, mods, I love you with all my heart. And chat, cupcakes, if I don't see you soon, I'm going to die, but I'm going to see you tomorrow. I just don't know what time. All right. Peace out, my friends. Stay cool, stay kind, stay classy. Above all, stay safe. Don't believe everything you read on the internet. And one day, maybe one day, we will get justice for John O'Keefe and free Turtleboy.